My lord, may I have your lordship?
Yesterday I have answered your lordship. It was listed on the item number 200. Today fixed for evidence.
Yes.
If you heard any day.
Then
Any day.
today is fixed for evidence.
Yes, today. That's why
Motion answer. It's appearing in the list.
yes, 200K.
Any caveat is there?
No.
There is no caveat. Can you come at 12:30?
What
about it? Item number
200.
210.
Yes.
Mentioning
Mundo, there is no caveat.
No, there is not.
item number
Come at
59.
12:30.
I'm mentioning item number 217, my lord.
Yes.
This matter previously, my lord.
Yes.
This matter, my lord, the learned executing court directed take possession with the help of by breaking open padlock on by 10th of June, my lord.
10th of June.
Yes, my lord.
It is appearing in the list.
217.
217
Yes, sir.
tomorrow.
My lord remembers
Okay.
yesterday, my lord, item number 39. My lord, I was led by Mr. Shumon Kumar Dotto, who was appearing online. My lord, he stated that there is another civil revisional application which will be filing.
Which will be filed.
My lord, it is ready. My lord, leave be granted. Let these two revisional applications be
It is
appeared.
filed thereafter. I will consider.
My lord, it is ready. My lord, client has come all the way from Bombay. He is here in the court also.
File it. It
My
will
lord,
appear.
my lord, tomorrow leave has to be given so that the matter will appear tomorrow.
Leave to appear.
Item number
Tomorrow.
59, which I mentioned
Item number
59, that the injunction matter regarding the holding of puja, annual puja, your lordship was pleased to direct that if the matter could not be reached, then mentioned in this week. 59 months, there is some urgency, my lord.
tomorrow.
As well.
My lord,
Lordship may be
59 tomorrow.
15, 59.
Your lordship may be permitted to mention
Item
120.
120.
Yes, madam.
Yes, Mr. Chatterjee, what is the urgency?
Because of the nature of the injunction, my lord, the petitioner is unable to enter his flat. My lord is very kindly included
When the order of injunction was passed.
just before my lord left for circuit, my lord, 27th March. And my lord included it in the list.
There was a bench.
Yes, I tried. There was a caveat and the caveat didn't appear. That
So,
is why it couldn't be.
are you mentioning upon notice to the caveator?
I mentioned, my lord, last Wednesday upon notice, my lord included it. But
Have you mentioned upon notice?
yes.
Then
Let it be taken up tomorrow. I'll again give notice, my lord.
tomorrow may not be possible. Let me see. Yes.
my lord, another matter we come up with the list only. When is civil revisional application against the order of the Alipur court, only to be listed, my lord. Only mentioning it's not coming up for a long time.
Please mention tomorrow. Yes.
My lord, may I be permitted to mention one extension of interim order?
When it will be expiring?
Expired on March, we have filed the extension application beforehand.
For the sleep.
Your Lordship, yesterday I moved a matter before your Lordship and your Lordship was pleased to fix the matter today. I have taken instruction. The matter is fixed on 22nd. This is with regard to maintainability of the preemption application. It is appearing as item number 38. Probably your Lordship.
38.
38.
Please wait. If it is not called on, then I will see.
May I mention at 1 o'clock, your Lordship?
May I permit to mention one matter, my lord? Item number, my lord, 284. My lord, your lordship.
184.
Yes, my lord. That
What do you
matter, that matter, my lord, your lordship, my lord, directed to appear as to be mentioned today, my lord. Because, my lord, I am ready and willing to kindly see the order, my lord. I am ready and willing to pay the amount, my lord. Pay the amount, my lord, entire amount by installment. Bank has directed to take instruction. I am 5 lakhs, my lord. At present, my lord, 8 lakhs also. My lord, 10 lakhs it is, my lord.
Have you given notice to the other side?
I talked to my lord Somanlo Ganguly, my lord. He has no objection. If your lordship take up today, tomorrow at 2 p.m. or my lord tomorrow.
Leave to file this.
Yes, I will also inform my lord.
Please inform the other side. Yes, call the list.
My lord,
Yes.
may I permit it to leave to file this, my lord, CO application, my lord. The award was passed, my lord, Cooperative Election Commission, my lord. This copy should be treated as a certified copy, my lord. This is obtained from the department, my lord.
If to file without the certified copy.
Inclusion, my lord, means
Please use the microphone.
my lord, inclusion, my lord, or wrongly
Please
filed,
come
my
tomorrow.
lord, expect
Yes, please call the list.
Item number 1.
Lordship, item number 1, I am appearing for the petition. Lordship, this matter is appearing for correction. Probably the order has been wrong inadvertently.
Oh. No, there is a typographical error in the
Instead
order.
of 2025, it
This has come as per my
Yes.
request that your lordship appeared for the petitioner in one of the matters.
It has been
Your Lordship, I am appearing on behalf of the petitioners.
Your lordship,
I do not want to proceed with the CO.
Uh,
The instruction, since the petitioner number 3 has affirmed the affidavit, for this reason, he has written the instruction, Your Lordship. C, sorry, my lord, C.
it has been submitted.
Or, well, answer the petition. Extension of interim order.
Yes.
It was originally granted, my lord, as page 9, my lord, on 17th January. Was further extended by your lordship on 5th March.
Who is appearing for the other side?
I'm my lord, to be very honest, my lord, I sent my lord the copies, my lord, of the application interim, my lord. My clerk has gone, my lord, to get it affirmed, my lord. It is yet to be served. It is yet to be served.
Then
My lord, last occasion.
when have you said this?
No, my lord.
When have you forwarded this?
A copy, my lord, that was sent, my
Yes,
lord.
because it,
Last occasion at page 11, my lord, that time, my lord, nobody appeared.
yes, 5th of March, this order was passed.
Yes.
So do you have filed another application?
Another application, can too.
But you have to serve unless the service
My lord,
is
to-
ready. How
that-
can-
I was very candid, my lord, it was sent. It was sent, my lord, immediately, my lord, after the same being filed, my lord. But my lord, last occasion also, my lord, at the time of extension, my lord, despite service, my lord, none appeared.
Can two? Where
Can-
is can two? Can two टा होता है? Can two नहीं तो मतलब? When have you sent?
My lord, last Friday.
You are appearing.
No, my lord, we are
When have you sent?
last Friday.
Last Friday. Where is the address?
Address is, my lord, Purba Midnapur. May I come back, my lord, tomorrow with affidavit service. Come back tomorrow with affidavit service.
Tomorrow it will be served.
I hope, my lord.
All right, then I'm making it not
Yes,
today.
that is better, my lord.
Yes. Not today. Yes, next.
I
My lord, this is my application, my lord. My lord, this petition was originally filed under 226, my lord. Coordinate bench, my lord, was pleased to grant interim protection, my lord, up till today. And my lord converted to a 227, directing us to approach your lordship, my lord.
What is the impugned order?
Impugned order is, my lord, an order of the Debt Recovery Appellate Tribunal, my lord. I'll just tell your lordship the background in one moment, my lord. Debt Recovery Tribunal, my lord, Guwahati, passes a recovery certificate, my lord. I am the guarantor, not the principal borrower. I prefer an appeal before the Debt Recovery Appellate Tribunal with two applications, my lord. One is for condonation of delay of 137 days, and the other is, my lord, for waiver of the pre-deposit. My lord, on the given day when the order impugned was passed, the waiver application was not on board at all. The law, to my humble understanding, is, my lord, until the condonation is decided, the appeal cannot be entertained. So it cannot be disposed of either. But however, without hearing the condonation application, my lord, the DRAT proceeds to, my lord, dismiss my appeal on the ground that the pre-deposit is not made. My lord, it is only in these circumstances that, my lord, I am constrained to
Then
approach.
you
your
are not entitled to any order of stay also. There is no appeal in the eye of law.
My lord, before the Debt Recovery Appellate Tribunal,
Yes, there was no appeal in the eye of law. You are not entitled to any interim
my lord,
protection.
I had asked for, my lord, the condonation to be entertained first,
Yes, so there is
137
no
days.
appeal in the eye of law.
But
How can you obtain an order of injunction? Please satisfy me on that.
my lord, if your lordship is pleased to remand it so that I can approach the DRAT, I am satisfied, my lord. That is all I ask for. My humble submission, I have, my lord, case law.
So,
special-
Without any interim protection. Without any interim protection.
Yes, in that circumstance, my lord, I can approach the DRAT for interim protection. That also will suffice, my lord. I will do that.
You are saying that how could this pre-deposit be directed without deciding the section 5?
Yes, my lord.
On the other,
I appreciate what is falling for your lordship. Yes, I
you are
appreciate.
entitled to any interim
If your
protection.
lordship,
You
yes,
can direct the condonation or delay to be heard out, but without any interim.
yes, my lord.
well, this,
Until at least the condonation is heard out, my lord, if some protection
No,
is given.
sir.
he ought
That is
to,
why I'm saying.
he ought
There is
to
no appeal in the eye of law. If you take that point,
Yes.
this point will come against you.
he ought to have moved this application before they.
Since I have a leader in
What
matter,
will-
my lord, let me come back tomorrow with this instruction, but I appreciate what is following from your lordship.
If you take this
It-
point, this will.
Yes, yes, my lord, I appreciate. That is completely correct.
Yes,
May I even come, kindly make it not today, let me come back tomorrow.
yes.
I am grateful. My lord, let it retain its position in the list, my lord. because-
Written position. Yes,
Very
call the next
good.
matter. 6.
I am for the petitioner, my lord.
Yes, have you served?
Yes, my lord.
Where is
I-
the affidavit service?
My lord,
You are
these are-
appearing.
Yes.
Mr. Sanjeev Kumar Mukhopadhyay is appearing for the
Where is he?
opposite parties. My lord, kindly praying, I'm praying for the Passover.
Passover. Or tomorrow if you want. Tomorrow.
So, my lord, kindly Passover the matter, he is on his.
Passover.
Seven.
So item number 7, my lord. I'm
Matter
appealing for the petitioner, my lord.
Matter
Yes,
was
sir.
heard by your lordship on the earlier day. Both the parties even reply.
Yes,
Only one-
what is the date fixed in the miscellaneous appeal? What is
My
the
lord, I'm being told, my lord, on the last
Tomorrow.
occasion it is tomorrow. I'm
Tomorrow?
told tomorrow.
No, he is wrong, my lord.
I might be wrong, my lord. I'm
tomorrow is
told.
the
I'm
fixed.
informed.
Tomorrow is the date fixed for order 6 rule 17 of order 21 rule 101. What he is saying,
order 6 rule 17?
17 of that is amendment in respect of an application under
Before
order
the appellate court.
before
Yes,
the
yes, before the appellate.
appeal cannot be heard.
What? No. I'm not saying for hearing of the appeal. I'm only asking what is the date fixed in the appellate court.
Tomorrow.
Tomorrow.
But my lord, your lordship heard this matter. My lord, only two points, my lord, I shall add.
No. Our
Your lordship, no, 2 minutes, not more than that.
judgment is ready, Mr. Banerjee. Yes. I've only asked.
One thing
I've
I
only
may-
asked.
no,
What is the
one
next
thing
date
I
fixed?
may say to your lordship, my lord, even your lordship in the Lord at the time of writing judgment, change your lordship's mind. I have seen.
No.
Lord,
That is
2
the- that
points
is one
only.
thing,
I
but-
don't, my lord, only 2 points. If your lordship,
Mr. Banerjee, no.
yes,
Yes.
all right.
Because it's ready now. The civil revision applications stand disposed of with the following observations and directions. The impugned orders are set aside and the stay application filed by the ferrometals and PXL are restored to the file of the learned additional district judge, fast track court to Howrah. The learned additional district judge, fast track court to Howrah is requested to dispose of the stay application as expeditiously as possible, but preferably within a period of 8 weeks from the next date fixed in the miscellaneous appeal. Title execution case number 5 of 2011 shall remain stayed, subject to the condition that ferrometals shall pay a lump sum amount of rupees 4 lakhs by way of interim occupation charges to the decree holder on or before the next date fixed in the miscellaneous appeal. If the aforesaid amount is paid within the time limit as specified in paragraph B1 above, the order of stay shall stand extended for a further period of 4 weeks or until further orders to be passed by the appellate court, whichever is earlier, and ferrometals shall be permitted to file materials, evidence, and a report of an expert in connection with the stay application. Failure to comply with the conditions stipulated in paragraph B1 above would result in automatic vacation of the order of stay of the title execution case, and ferrometals shall not be permitted to file any materials, evidence, and a report of expert in connection with the stay application. In the event the stay application could not be disposed of within 4 weeks from the next date fixed in the miscellaneous appeal, the appellate court will be at liberty to extend this order of stay for a limited period, subject to payment of a further sum of rupees 4 lakhs by way of interim occupation charges. This is with regard to ferrometals. Now is PXL. Title execution case number 5 of 2011 shall remain stayed subject to the condition that PXL shall pay to the decree holder a lump sum amount of rupees 3 lakhs by way of an interim occupation charges on or before the next date fixed in the miscellaneous appeal. If the aforesaid amount is paid within the time limit as specified in paragraph C1 above, the order of stay shall stand extended for a further period of 4 weeks or until further orders to be passed by the appellate court, whichever is earlier, and PXL shall be permitted to file materials, evidence, and a report of an expert in connection with the stay application. Failure to comply with the conditions stipulated in paragraph C1 would result in automatic C1 above would result in automatic vacation of the order of stay of the title execution case, and PXL shall not be permitted to file any materials, evidence, and a report of the expert in connection with the stay application. In the event the stay application could not be disposed of within 4 weeks from the next date fixed in the miscellaneous appeal, the appellate court will be at liberty to extend the order of stay for a limited period, subject to payment of a further sum of rupees 3 lakhs by way of interim occupation charges. All payments made in terms of this order by way of interim occupation charge shall be adjusted against the occupation charges which Ferrometal and PXL shall be directed to pay to the decree holder by the Learned Appellate Court. Learned Appellate Court is requested to take up the hearing of the application for release of the balanced land and dispose of the same in accordance with law as expeditiously as possible.
Including the application for releasing.
That is the releasing.
Lordship. No. One is a stay, another is releasing the other portion of the land.
Yes, that is what I am
Oh,
saying.
yes. I am sorry.
It is requested to
I'm
take up the
sorry.
hearing of the application for release of the balanced land
But I
and
beg to be excused, my lord. I beg to be excused.
and dispose of the same in accordance with law as expeditiously as possible. It is however made clear that the Learned Appellate Court shall be free to decide on the rate of occupation charges without being influenced by the amount directed to be paid by this court by way of interim occupation charges. No cost for a certified copy.
My lord, only one thing, my lord, but may we have tomorrow is the next date. May we have my lord said on the next date fixed. So, my lord, next date 7 days or 8 days, my lord, kindly be granted. My lord, tomorrow is the date. Well, we will not have the server copy also.
I did not knew that tomorrow is the date. That is why before.
No,
cross-
tomorrow is not the date. Date is to be fixed for that because in view of the
So I'm
lordship's order.
on or before
4 weeks. Your lordship said 4 weeks.
tomorrow, if they do not, they will be in violation, Mr. Banerjee. Today I am dictating. So they will be in violation and the
No.
Learned
No,
Appellate
no,
Court
no.
will say I cannot extend that.
No. Right.
So how soon can you deposit, Mr. Chatterjee? Because
My lord,
the
by a week. My lord, if by a week, but by a week, my lord, trial courts are in vacation.
yes, so will open on 2nd of June,
2nd of June, trial court will open.
3rd of June, on or before. So I'm making that change.
And my lord said to be paid to the decree holder. My
Yes,
lord, instead of deposit in court because decree holders' accounts are not furnished to us. So we don't have the accounts to pay them.
Account number.
all right. So I'm also providing for that.
Yes.
Preferably within a period of
Self-furnished account number.
8
To Mr. Chatterjee
weeks.
or to the learned advocate of the
The
trial
next
court.
date fixed in the-
Whatever you are to say.
shall remain state
To
subject
the
Because
learned advocate of the trial court.
on or
Yes.
before.
Because I respect Mr. Chatterjee to you.
On or before
My lord,
3rd of June.
my lord.
on or before 3rd of June to the decree holder. I will be changing in all that. That will be 3rd of June. And Mr. Banerjee, please furnish the bank accounts.
Yes.
At a order at a line লিখে the please do it here so that I
That
think
is why I told Mr. Chatterjee.
Mr. Chatterjee, please, before this court.
Yeah,
Otherwise, before this court.
that is why I
Lanet
physically
advocate
I
record
told
of
Mr.
ferrometals
Chatterjee.
and PXL before this court.
Very well, very well.
Deposit the amount to the bank account, the particulars of which shall be furnished by the learned advocate on record of the decree holder to the learned advocate on record of ferrometals and PXL appearing before this court.
May I request Mr. Learned Senior Advocate, Mr. Banerjee, to furnish it by tomorrow because advocate on record would be leaving Calcutta on 22nd. So, my lord, if he leaves, my lord,
Mr.
then
Banerjee says he will furnish it.
I said,
And Mr. Chatterjee, if that is so, you can give your mobile number or the email ID so that it can be furnished nowadays.
Yes, yeah, now
Wherever you are, or your advocate on record is.
advocate on
they
record,
will
email
get that.
number, WhatsApp
Please
number.
furnish
my lord, Junior is traveling internationally.
Number. Kindly give me WhatsApp number. I shall.
Yes, give the WhatsApp number, he will send that.
Yes.
আচ্ছা এটা পাঠিয়ে দিন।
I am deeply obliged, my lord. Lastly, I say why your lordship did not allow me to make submission. I am deeply obliged.
That is the, because there are
No,
so
no,
many
no,
facts,
I
that is the
understood, my
reason
lord.
why I
That is the proper
why I
order,
thought
my lord,
that
as your
it should be-
lordship has been free to pass.
I have to prepare that.
Lordship, lordship.
That is the reason.
Yes.
আচ্ছা একটা জিনিস।
My lord, 8 and 9.
Four matters
My
are
lord, 4 matters together, my lord, 7, 8, 9, 10.
Yes, 4 matters.
Four matters are the-
I've said for, that is why I've taken it together, otherwise it will be. আচ্ছা একটা জিনিস, চারটে তো একসঙ্গে Thank you both Mr. Banerjee, Mr. Chatterjee. Yes.
item number 6 passed over matter here, other side has come.
Yes. Yes.
Item number 6.
Yes. Call item number 6. Yes.
I am for the opposite party, my lord.
Yes. What do you say?
Lord, kindly come to page 28 at first. It is a lawyer's letter. Kindly see my what has been assailed against my lord's own officer.
Page 28.
Page 28, annexure E.
Page 28. Yes. Yes. What is there?
My lord, somebody may be aggrieved by my lord's order, but does it mean that in order to put more pressure in the revisional application, or my lord, in the he will file a complaint before the learned district judge against the very presiding officer?
All right, please come to the merit. Yes.
Well, this is the affidavit of supplementary. I filed again as per my lord's opinion. I filed it in the stay application, execution. Sorry, miscase for setting the application. And the kindly see the application. Then on okay.
That copy has
original is
been
coming, my
served
lord.
upon me. This supplementary affidavit has not been served upon me, my lord, as on today.
Why do you not serve him?
My lord, last date was order was passed on 14th May. I moved it on 16th May. And this notice that sent against me. And my lord opined on the last occasion that I should make an application before the state application. Not all done.
I have not opined anything. I have only recorded
Yes,
that
my-
he has submitted that no stay application with the miscellaneous case has been filed till date.
Yes, and it was open for the so as per my lord's opinion, I
I
filed.
have not directed you to file any application.
Yes. Now, my lord, summons has not been served, and my lord, this application for stay in the execution case.
What is the order under challenge?
My lord, see. Only 11/2/25. 11 February 2025.
11th February 2020. Yes.
This time also the DQL did not accept the copy of application, stay application, always he averted the service. This time also, I sent this revision application, yesterday he sent back.
Oh.
And my lord, Mr. Mukherjee appeared on the 41st occasion.
Yes,
What is the miscase 84 of 2024 for?
That is my application for setting as expiry decree.
Order 9 Rule 13.
Order Rule 13, my lord.
Yes.
On the ground of
Pending.
and my lord, summons are not issued from the record.
Order
Summons
9
not
Rule
issued.
13.
Yes, my lord.
Yes, Mr. Mukhopadhyay, please appear in that. Otherwise, it will be delayed. Otherwise, your proceedings will be delayed.
my lord,
What is the next date fixed?
My lord, there is 30th July.
my lord,
Once he refused to accept some notice.
really appreciate it is their specific case. They are aware of this proceeding. They, my lord, appointed an advocate. That advocate had taken
Which proceeding? Which proceeding? The
It is
original
the
proceeding.
eviction proceeding.
Contest that because they have filed an application under Order 9 Rule 13.
30.
Get it dismissed on merits.
Yes.
So I'm directing, please enter appearance. I'm directing that miscellaneous case to be disposed of as expeditiously
Yes.
as possible.
Only thing, my lord,
And what is miscase 1 of 2025? What is that for?
That is miscase for police cell. Already
Police cell.
order has been passed. The date is fixed for police report on the police cost.
Yes.
my lord knows, my lord, even if this miscase is allowed,
And summon is
by-
not served.
by virtue of my lord's prerogative, the possession will be restored.
Why?
It's a different thing.
My lord,
So,
My lord, enter money is paid. It is not a eviction suit.
Order 9 Rule 13 has been
Yes.
filed and you have also paid for stay.
Yes,
When the application for stay will come?
for June.
4th June.
Yes.
All right. So I'm passing a limited protection for a limited time and I'm directing the executing court to take up the hearing of that. And please enter appearance. You have not been served with a copy of Order 9 Rule 13.
Order 9 Rule 13, my lord,
Annexed copy, annex the copy.
You have annexed the copy?
Yes, revision application.
he has annexed, but this supplementary affidavit has not been given.
All right. I'm
I
directing.
As your lordship desires, my lord. I
Avoid
stand
solution is always.
The
application. It's a suit for declaration of title and injunction and recovery of possession. The plaintiff's application for amendment has been rejected by the learned trial court.
Plaintiff's application for amendment, what is the suit for?
Amendment of claim.
What is the suit for?
Suit for declaration of title,
Please use the microphone.
declaration of title, recovery of possession and injunction.
Where is the
Defendant number 1 and 2 are licensee. They are trying to deny my title and somehow
What
recorded
stage did you file this application?
belated stage, my lord. Belated stage.
Where is the application for amendment?
Amendment, kindly come to my lord. Nature of the amendment, my lord, kindly come. Page 18 is the schedule of amendment. Kindly for once, my lord. Plus very formal in nature, merely clarificatory. And mostly, my lord, only apart from one schedule, my lord. Kindly come to that the name and address of the defendant number 4 be deleted. 4
How
is
can that be done in amendment? How can that be done by way of amendment?
by exercise of power under order 1 rule so motu court can delete. And 2 is consequential. If 4 goes, 4 to 11 will come to 5, 4 to 11, 5 to 12, and kindly come to 3, my lord. The para number 1 of the 4th line, after the digit 38, the words except quantum of land be added. But in the kindly come to paragraph. What is paragraph number 1, my lord? Page, my lord, 12. That part and parcel of the Bastu land measuring 22 decimals RS plot number such and such appertaining to RS Khotian number 38 corresponding to LR number was by virtue of the inheritance the absolute property of Ruhul Amin Mondal and Amiran Bibi. The fact duly recorded in RS Khotian number 38 of Mauja. In between 38 and of Mauja, these words is to be inserted, my lord. Except the quantum of land. Quantum land is not mentioned in the Porcha. That is a minor, very simple amendment. That can be.
All right. Anything more?
Third one, kindly come to third one, Miller.
Yes.
After the para 1 of the plain, the word it is stated the land ordinarily owned and possessed by Karamtullah, the father of Ruhul Amin. It is just recital in the nature recital how he have come. It is missed out in the plain. Explanatory, mere explanatory. And fourth one, Lord, after the the word son be added. Otherwise, it is meaningless. Lord. Only, kindly see, only son is mere. And the fourth one, Lord, of the defendant is BLLRO. No relief has been prayed for against BLLRO. No allegation is made even. Therefore, but now it was found at the time of hearing before argument, it was learned senior advocate found that in fact a notice under section 18(1) was given. It was missed out. That's why only for just clarification. Though no 18 is not necessary in my aspect. But learned court has made the observation 18 is mandatory, and that may prejudice my right. Prejudge this. That is the only thing.
This application under Article 220. Yes.
I appear on behalf of the plaintiff's petitioners. My lord, before the matter is taken up on merits, kindly peruse page 45 of the revisional application.
Yes.
This is an old suit that was instituted by the plaintiff's father on the same subject matter. Your lordship appeared for one of the parties.
Ashun. Yes.
In this matter, I appear for the petitioners.
Yes.
The eviction order passed by the learned Waqf Tribunal under section 54(3) of the Waqf Act.
Encroachment.
Encroachment.
What is the wrong?
Or because, my lord, the petitioners are the licensee.
On facts, it was found there is an encroachment.
My
It
lord.
has to be removed.
My lord. Earlier, my lord, 3 title suit was filed by the Matwali before the learned civil court at Sialda. All the title suit was dismissed. And in the one of the title suit, the Matwali admitted that the petitioners are the licensee. And since 1950, before that, 1921.
Show me that how this point has been dealt with by the tribunal.
Well, page 59, the inner page 4 of the judgment. May I read?
Where is the order of the civil court?
A civil court, that suit, all the suits are dismissed for default. Restoration application was filed, that was also dismissed for default.
Then no issue has been decided.
So,
Issue has not been decided.
but they have submitted, Matwali filed the written statement. Filed the suit.
Yes.
And the suit,
If the suit has been
in
dismissed,
the plain, my lord, he admitted that the petitioners are the licensee of the premises.
yes, maybe at that relevant point of time, when they file the suit for eviction, that means they have terminated the license and have filed the suit for eviction.
No, license was submitted in writing.
Show me the plaint.
Paragraph, my lord, kindly, my lord.
Page 4,
page 5 of the judgment, page 60 of the application. Second paragraph. Inner page 5 of the judgment, second paragraph. This is also further submit the one Abdul Rajak. Plaintiff has comments the
No,
one.
the case of trespass was also mentioned there. Trespass was mentioned there. It's their case. And if on facts it has been found that there's an encroachment, where is the infirmity in the order? Show me the procedural infirmity.
Because the Waqf board has passed the order.
No. Waqf board cannot pass an order, it's the
Recommend.
tribunal.
The Waqf board has recommended.
Has to be. That's the procedure under the law. Once an encroachment is found, it has to recommend to the tribunal. Tribunal has to decide. That's the procedure under the Waqf Act.
The Waqf board, without hearing the parties,
Waqf board only has to make an inquiry. If upon that inquiry it is found, it has to relegate the matter to the tribunal. That's the procedure.
Tribunal. But tribunal, without taking my evidence, I have produced the evidence that was not taken by the tribunal. Learned tribunal. But since 1950, they are residing in the premises. Before that, they came from East Pakistan.
Show me the report of the inquiry dated 26th of February 2021. Your only point before the tribunal was that there was a suit, it was dismissed, barred by res judicata.
And
You have,
also
it's not barred by res judicata if it is dismissed for default. That issue goes. You have not raised any.
Before this act, suit was filed.
Yes, yes.
Dismissed.
So that issue was not decided, Mr. Sengupta. If that is not decided, how the question of res judicata comes?
But they filed the suit. They filed the suit.
Yes. Dismissed for default. Now the new act has come. Where is the bar to file this? Show me the bar. If there is no bar and there is an inquiry report states that you are encroached upon the property.
It was dismissed for default in the year 1998. After this act, after this act, 1998.
Yes.
That restoration application was filed, miscase filed. That was also dismissed for default.
Is it a bar in proceeding with this? Show me the law. If you want, I can post it after the vacation, Mr. Sengupta. Without any interim order.
And otherwise, they would be evicted
Then-
from the premises since
then I can
1921.
decide.
1921. Otherwise, they would be evicted. Limited.
Show me something. For
Limited
a,
relief.
no. What for? It's not at the mere asking. Res judicata, nothing. Show me the report states you are an encroacher.
Or let the matter be fixed after vacation.
After some argument, the learned advocate appearing.
But plainly in a suit for specific performance of a contract.
Yes.
Now, my lord, I filed an application, my lord, for recalling myself as PW1. Now, my lord, I wanted to prove my readiness and willingness. But after the agreement,
What did you do when you actually deposed?
my lord, those deeds, my lord, I did not have it with me. Certified copy of deeds kindly comes to my petition for recall once, page 78. My lord, kindly see.
Cannot be allowed to fill up the lacuna in evidence.
I just, my lord, these are all public documents. I want to mark them as
Why
exhibits.
did you not file this at the
Because I didn't obtain the certified copy of those deeds.
That is your application.
So it kindly comes to page 78.
This is the stage of the suit now.
Evidence has been closed, date is fixed for argument. But only one day I shall mark these documents as exhibits. Kindly comes to paragraph 6, page 79.
Let me go through the order.
Lordship.
So you want to prove your readiness and willingness by producing some deed.
Lordship.
How can that be?
But only thing is, my lord, what I want to produce is, my lord, when the agreement for sale was executed by and between me and the defendants, my lord, thereafter, my lord, when the defendants were not ready to, my lord, grant me possession of the property, with that money, my lord, I had purchased some other properties. But with that readiness and willingness.
That cannot be said to be readiness and.
But kindly, my lord, see, my lord,
I can decide on that also.
No, but only thing is, my lord, I had
That
the money
cannot
with
be-
me, my lord, with
That
that.
cannot be a ground. You have to show that you are ready and willing to. Where is your evidence?
My lord, kindly come, my lord, I have given
Give me your evidence.
My lord, my chief is at page 60. My affidavit in chief is at page, my lord, 47. My lord, 2,73,600 was settled. I have already paid 1 lakh.
That is neither here nor there.
Now, my lord, kindly comes to my chief. My lord, page 47 onwards.
Where is the relevant portion with regard to Readiness and willingness.
Well, that point, has been missed out. That is why I want to.
So,
Well,
say lacuna.
kindly, I want to recall. Sees the
Your application.
well, it kindly comes to page 78.
78.
Well, paragraph 4, 5, and 6. All deeds, my lord, executed after, my lord, the agreement for sale, my lord, was entered into. And 6 is the schedule of the deeds, but which I want to mark as exhibits.
Where is your explanation? When did you obtain these deeds? How did you obtain these deeds? Nothing.
But that will be mentioned in the deed itself.
No.
That will be mentioned. But that will be mentioned in the deed itself.
Yes. Anything more?
Kindly, come. Lordship sees these are all public documents under section 74 of the Evidence Act.
Prevented you from producing those at the.
I could not, but I did not obtain the certified copy.
Show me where have you stated when you obtained this? Show me from your application.
But may I file a supplementary application?
No.
May I file a supplementary before this requirement only before that it's certified copy of the deeds. But one day, my lord, I shall require one day W1. My lord, there is prior, my lord, if she fixes, even I shall produce those documents. I shall not delay the trial. I am the plaintiff. I should not be doing that. My lord, one day I shall mark those deeds as exhibits. These are public documents. But kindly, my lord, one day I was praying for.
This application Next matter, yes.
Item 15, I am for the petitioner, my lord. I am aggrieved by the quantum of alimony pendenti light which has been awarded to the petitioner wife, my lord, in connection with the miscase.
You are the husband.
No, I am for the petitioner wife, my lord. I am.
Oh, you want enhancement?
Enhancement, my lord. The husband has admitted in his
Lordship, being informed and instructed by my client that once you has been filed challenging the order passed.
You want reduction?
Yeah, opposite party to serve the copy upon us, and we
But they have not
delighted to
preferred any
file this,
application for.
file this power before this lordship.
My lord, they have not preferred any applications for.
Much obliged.
So what you are saying, some alimony has been granted, you are paying for stay. I will allow your prayer. Please apply your mind before making any submission. Something has been granted and you want stay of that. Yes, Mr. Bose.
Section 5 rejected in an appeal.
Limitation Act.
Limitation Act Section 5 condonation of delay rejected in an appeal before the Debt Recovery Appellate Tribunal.
Oh, Debt Recovery Appellate Tribunal.
I'll tell you, Lordship, what has happened. My lord, the original application, these are, my lord, I'll tell you,
What
Lordship.
is the period of delay, Mr. Bose?
According to us, 81 days.
According to the tribunal? According to the appellate tribunal?
No, that is not the reason. He also accepts that. He says, I'll tell you, Lordship, what, just 2 minutes of your Lordship's time. My lord, these are micro loans given to.
Mr. Bose, unless you serve.
Yeah, I can understand. And I can understand. My lord, he
bank.
Canara Bank. I am not the borrower, I am not the guarantor, I am not the surety. I am a e-platform. So, my lord, for 3 states in South India, my lord, these micro loans are given to farmers. So, and the goods and the produce.
Where is the impugned order?
Well, the last annexure to the
Volume 1, Volume 2.
Volume 2.
Thankfully, it's not Volume 3.
Well, kindly take paragraph 15. He refers to about 7 judgments, all are in my favor. And thereafter at paragraph 15, this is what he holds. That what I did at before the Debt Recovery Tribunal, he holds that to be negligent.
Where is your application?
My application for condonation of delay. Your Lordship will can. He records it himself. In this, your Lordship need not look.
Where is that?
No, my lord, page 29 of the revisional application.
No, where is the application under section 5?
Yes, page 29 of the revisional application. Well, there is a procedure in Debt Recovery Tribunal that after the final order is passed, it is required to be communicated by the tribunal, like my lord, orders before the National Company Law Tribunal.
Where are the grounds? Which paragraphs?
My lord, the grounds in the revisional application.
No. The ground for delay.
Yes. Now, my lord, if your lordship will keep, first we are saying, my lord, I have in fact tabulated a sheet. If your lordship will kindly come, paragraph 20, page 36.
Page 36, paragraph 20.
Yes. And what he says is, he doesn't consider this my explanation, whether it is sufficient or not. He says,
by the order impugned, the application
no effect. I'll tell you Lordship why. I wouldn't have otherwise
There is
bothered it.
no appeal in the eye of law.
I know,
That is
but
the
your
beauty of
Lordship is exercising revisional. I'll tell you Lordship why. There are more than 100 loans.
Has it been put into execution?
Yes, that is the knowledge. The recovery officer has given me the notice of demand.
What is the next date fixed?
Before the debt recovery tribunal, well, I am told sometime in June.
When?
Now, it is not like a court. What the recovery officer does is he issues notice, which he has already run the demand notice, and then he proceeds.
Please apply. You can pray for time. Otherwise, you mention it.
Very well. Then madam, give me that liberty in the event the recovery they proceed with recovery, liberty to apply. At least give me that.
It will be open to the petitioner to yes.
It's a expeditious hearing by partition supervisor. My lord, it is filed on 2022, my lord. The defendant appeared in September 2022, my lord. Still date, they have not given any WS, my lord. And my lord, the injunction order was passed in April 2022, my lord. But my lord, that was not also, my lord, disposed of. My lord, kindly see the last order, my lord. 26/6/2005 for filing WS. My lord, last order, my lord, kindly see. So, my lord, kindly expedite the, my lord.
This application under Article 227. Yes, sir.
Small matter, small prayer.
Yes.
In the petitioner runs a pharmacy in his own shop. And pharmacy has been going on since long.
Haripur Court. Do I have any difficulty in taking up? Please ask your advocate on record to inquire. I'm keeping it to tomorrow. Please inquire whether I have any difficulty in taking up.
Haripur.
I'm keeping it for tomorrow, not today. Yes.
19.
Yes.
19, my lord, I appear for the petitioner.
Yes.
My lord, I appear petitioner husband. My lord, order passed under section 24 of the Hindu Marriage Act.
Yes.
My lord, my contentions are, my lord, my income, monthly income, my lord, which has been produced before the court, your lordship will find, my lord, from the salary slip, is, my lord, net pay is 34,700. And my lord, maintenance has been awarded to the tune of 25,000. As against the wife and, my lord, the minor daughter who is 7 years old. Since this is appearing for the first time, my lord, I know what is the procedure, my lord. My lord, let them come, my lord. I'm not also seeking any stay, my lord, in the proceedings for alimony. My lord, shortest possible date so that, my lord, I can serve and come back. And my lord, one more indulgence, my lord, there is a mistake on my part. My lord, the affidavit of assets of the husband, my lord, has not been disclosed. Though it has been pleaded, only the wife's has been there. So, my lord, I want to bring it on record by way of a supplementary affidavit.
Advocate appealing for the petitioner. within, let's the supplementary affidavit be filed.
Lord, I'm sorry to interrupt. Lord, what is the timelines your lordship has given? Because Lord, it was made offline. The order
Yes.
was dictated.
Soon can you file supplementary affidavit?
Lord, just 1 week within the vacation, after the vacation.
1 week after the vacation. All right, let's the supplementary affidavit. No, I have said before the honor, before the next date of hearing, but you have to
So,
serve,
lordship,
but you have to serve
yes,
an
yes,
advance copy of the same along with this.
both. Yes, both, my lord. Lordship is keeping it on.
Monthly list of July motion. Yes, next.
Grateful to your lordship. No,
Yes.
I have been on. No, 20 also I'm for the petitioner, my lord.
Yes.
My lord, this is a very interesting case. My lord, this is an order passed by the National Commission, which is under challenge before your lordship. Now, your lordship knows, in view of the two recent judgments passed by the Honorable Supreme Court, Lord, now the High Court exercising powers under 227 is the appropriate court prior to going to the Supreme Court. Now, Lord, the fact in issue in this case is that, Lord, the complainant, who is the opposite party hearing, Lord, had initiated a case against the petitioner hearing. Lord, in the district forum, Lord, there was only a direction to register. No compensation was awarded. That order was challenged by both the appellant, the complainant, as well as by us. Appeals were heard together as joint appeals, and the order passed by the district forum was affirmed. Now, my lord, your lordship will find all of a sudden, the National Commission had come to an erroneous conclusion that, Lord, kindly sees the last two paras of the impugned order, that's paragraph 9 and 10, whereby the National Commission has held that 9% simple interest has to be awarded by the petitioner from the committed date of possession till the actual delivery of possession. Here, my lord, the facts are, my lord, there have been breach of terms of the agreement for sale by both the parties. The complainant did not make the entire payment within the time stipulated, and as such, my lord, we refused to register. These aspects were considered by both the forums below. But, my lord, the learned commission took a contrary view and came to a conclusion that, well, I have to pay 9% simple interest on the date of committed possession. I may place both the orders of the.
When did you hand over the possession?
Lord, possession was handed over. I'll just, check up the date. Lord, it was during the proceedings of the execution itself, my lord. Execution proceedings is also pending.
Yes.
Now, my lord, this is in addition to, because on facts your lordship will find, my lord, there was a payment schedule by which he had to pay the complainant, which he admittedly failed.
Petitioner
That is why
petitioner is aggrieved.
Lord, here in this matter, my lord, I'll be humbly beseeching your lordship for a short stay, because one of the execution proceedings is
stay of what?
Stay of the execution proceedings, because one of the warrant of arrest is likely to be, my lord, issued against me.
There shall be an order of case number. Where is the execution case number?
My lord, execution case number, just hand over, my lord, to your lordship. Is there in annexure E, my lord. Lord, execution case number EA 26 of 2026, 2016. But annexure E,
No, no, you have the
page,
execution case. That prayer is not there.
the prayer, my lord, kindly sees.
Prayer of the stay of the National Commission's order, that cannot be granted. Order of stay of execution is not there. Yes.
Yes, my lord, I have not pleaded, but my lord, only one line, my lord, would help, my lord. In the meantime, no coercive steps to be taken. Otherwise, my lord, this becomes
Where
infractual.
have you stated that coercive steps are being taken? You have
My
not
lord, I
stated
have,
that also.
my lord, I have pleaded that execution proceedings is pending, my lord. I have pleaded, my lord.
You have not stated anything that what steps have been taken. Yes, call the next matter.
21.
The defendant number one, malad the appellant is the malad the petitioner before my lord. Malad
Yes.
suit for partition. Malad the plaintiff malad in the suit malad played for malad the his 1/6 share in the suit property.
Yes.
Malad kindly comes to malad
What is
page.
the order you are challenging?
Malad in my ad interim order of injunction was malad disposed of by the learned trial judge by directing both the parties maintain status quo.
Trial judge.
Trial judge against that malad preferred misappeal.
You preferred a miscellaneous appeal.
I preferred a miscellaneous appeal.
Yes.
Since I am the plaintiff is the plaintiff claiming his right over the suit property 1/6 share.
Yes.
Less portion is with me.
You are the defendant.
I am the defendant.
Yes.
Now, I could not start my construction. The condition of the property is that without.
What did the appeal court do?
Appeal court says
affirm the order of
the order passed. The directed status quo till the disposal of the suit.
No, you have said ad interim order.
That was disposed of. It's subsequently injunction petition was the disposed of.
Where is that?
Kindly comes to page 60.
60.
The prayer for temporary injunction stands disposed of.
But Mr. Ghosh, in a suit for partition, the question of who is in possession of what portion,
That is the I
taking
am
advantage of that, you cannot raise constructions on the.
without claiming in equity. Since
So
I
you
am
can file that application before the learned trial judge. You have not filed any application praying for.
that application.
Then
So in that even with that liberty otherwise.
that can be granted, but
I am the owner of the 5 and 1/6 share of the suit property. They are only 1/6. By virtue of this order, I am not able to make any construction. Kindly the consider.
there is no application, Mr. Ghosh.
Yes, that is true. There is no
the
application
application.
either of before the learned trial court or the learned appeal court. But before my laws, I prayed for give me permission to that
Permission cannot be, there cannot be a blanket permission. Where you will construct, in which portion, what is the extent, you have to specify all these things. It cannot be a blanket order giving you permission.
I shall give me liberty. I shall file application.
The defendant Yes, next.
22. May it please your lordship, Miller.
Yes.
I'm appearing on behalf of the petitioner, father of a minor son who is 7 years old, Miller. My request for interaction with the son in the nature of Miller and interim custody has been turned down. My request was to interact with the son on Sundays, 9 a.m. till 6 p.m. Miller, the impugned order, Miller, the opposite party was not on caveat. If your lordship Miller allows us to serve and come back, Miller, any day commensurate to your lordship's list. The ground is allegation, counter allegation.
Where is your application?
Yes, Miller. My application is at page 40 for interim custody.
Page
40, Miller, 40. Annexure G.
By the order impugned, the
Item number 23, my lord, advocate on record requested to take after vacation, my lord.
on the prayer of the learned advocate for the petitioner, hearing of
24.
Lord, I am for the petition.
Yes.
Lord, a suit for eviction is being initiated on the ground that Lord, original owner, Lord, original tenant was Dhirendra. Lord, Dhirendra died in 2013. Lord, it's Lord, order 22 rule 4 capital A application is being turned down by the order impugned.
Yes.
Lord, original tenant was Dhirendra. Dhirendra died, Lord, sometime in 2013. My suit is of 2015. I say after Dhirendra died, his one son and his wife is the joint tenant under me. Treating that, my suit is being filed.
Joint tenant or tenant in common?
Joint tenant. Lord, paragraph 3 of my plaint is very category. Now, Lord, during pendency of the suit, both Lord, the mother and son.
Why joint tenant, Mr. Mukherjee, are not tenants in common?
Lord, in both of the way, if your lordship Lord takes up, then also in a similar conclusion, I may say, because Lord, if it is a joint tenant, then Lord, survivorship is the Lord, rule. If it is from Lord, or through Lord, Dhirendra, then also Lord, the person who was residing with him, Lord, at that juncture, Lord, the wife and the Lord, son, wife, son both died during pendency of the proceeding. Now,
during pendency of the proceeding,
suit.
Yes.
And it is a case, Lord, where Karnani will not come into play because the Supreme Court said
Prior.
it's old, prior. So it's 2013, Lord, the original owner died, original tenant died. If that be so, today there is no question of right to sue survives.
Who is contesting?
No one. The learned judge says in the written statement, they said there are other married daughters. 2 of the married daughters are there. So the court is of the opinion, no, there are legal representatives. So order 22 rule 4 capital A will not come into play. Kindly sing Lord one second. Milord takes up 4 and 4A, Milord side by side. 4 says, Milord,
What is the meaning of the expression intermeddles with the estate of the deceased?
My lord, in 4 capital A.
Definition of legal representative.
My lord, here, my lord, your lordships kindly consider.
Order 22 Rule 4A, Mr. Mukherjee, it says one who intermeddles with the estate of the deceased. That is the expression. Then in that case, administrator general.
Today, if the right to sue, my lord, does not legal representative term has to be
Please come to
qualified.
the definition. Please come to the definition of legal representative. Two 11. Represents the estate of a deceased person and includes any person who intermeddles with the estate of the deceased. So it's an inclusive definition, not only who represents the deceased estate of the deceased, who intermeddles with the estate.
Today, my lord, I
Please think over this.
Yes, my lord.
So if this, why are you, so now the daughters are there.
What the court is
I
asking.
think it's for your benefit. You have to
What
include
the
the
court
daughters.
is asking, you filed an application for substitution, impleading the daughters. Once I do that, my ground under 2G goes. Once I say right to sue survive upon the daughters, because my positive, because not your lordship kindly.
Mr. Mukherjee, please look at the definition of 211. It's not legal representative has been defined two things. Means a person who in law represents the estate of a deceased person. There you may be right that he does not acquire. And inclusive includes any person who intermeddles with the estate of the.
But here,
who is
intermeddling statute will not take a override effect 2G.
Mr. Mukherjee, please understand this is in law. That is under the special statute. But it's inclusive anyone intermeddling with the estate of the deceased.
But today, my lord, whether
that is why I'm asking you, what is the meaning of the expression intermeddling with the estate? Does it mean only succession? Intermeddling with the estate. He also comes within the definition of legal representative. And 4A operates only when there is no legal representative. So there is no person who is even intermeddling with the estate also. One thing you are saying, under the law, they do not have any right. But it's an inclusive definition. Anyone who intermeddles with the estate may not have any right under the statute.
Otherwise, my lord, my suit without substitution, the court will say this.
Please apply your mind, because this will have a long way to go.
Because the court has noticed also the fact
Will
that
have a long way to go.
Yes, that's
and the
right.
trouble will start.
Yes, the court has recorded. Lord, I want to take that also. That is recorded, that they can come up with ventilating his grievances under Order 21, Rule 99 to 101. Because
the different thing. That is the different thing altogether.
Because this thing, my lord, whether
that cannot be a ground. I'm telling that in another way. That cannot be a ground for applying Order 22, Rule 4, capital A. Unless you can say they do not fall within the expression of intermeddling with the estate. It's very difficult to say that. Anyone who is intermeddling with the estate of the deceased, not under the law, who succeeds. There are two things. This is an inclusive definition. So anyone may not be a tenant as per that section 2G, but may be a legal representative of the estate of the deceased, and they may have a right to be substituted. Or you have to decide.
May I come back? Lord, I understand, Lord, what is troubling your lordship. Lord, this is also, Lord, otherwise, this 2G will not be given effect at any, once at my juncture, Lord.
Not that, Mr. Mukherjee.
No, 4A may not be, Lord, I may not resort it to 4A. In view of this.
But so, you have to draft that application very carefully.
Yes, I understand, Lord. That's why. It's not a general way of substitution.
It's not a general way of substitution.
Has to be.
You have to.
If this intermediate term will includes that legal heir who may not have right of, yes, to survive,
May not succeed as a tenant, but may be a legal representative under 211.
It's really an interesting point. My lord, keeps it after vacation immediately. My lord, it's my suit, my lord, ultimately. So keeps it after vacation. My lord, I shall try to, my lord, kindly fix it, my lord, in any day in supplementary list. So that, my lord, only that portion, my lord, I shall, my lord, try to address before your lordship what will be the term of that term, whether it includes, my lord, even if considering 2G, those persons to whom right to suit even does not survive. The because Kanji Manji and Milord, the subsequent judgment of this honorable court were in joint tenancy, it's survivorship. If two of the joint tenant, both of them goes, Milord, its tenancy rights evaporates. And my case is that 2G is my alternative case.
2G is your alternative case.
Has to be because Milord kindly once looks at my plaint.
Main case.
My plaint kindly once looks at. I say after the death of Dhirendra, the son and his widow become the joint tenant.
Yes.
So my case start from there.
Yes.
So if that be so, so two of them died. So there is no question of the inheritance in a joint tenancy.
Yes.
So if I stand on my plaint case as on today, it is obviously not subject to proof. Ultimately,
who is in occupation?
No one. After death of both the parties, no one. It's a married daughter, two of married daughter. One of the daughter already predeceased. And they have not come up. It's in the written statement. I have annexed also the written statement. Written statement, paragraph 13, Milord, they have specifically mentioned that. Non-joinder of necessary party in my suit for eviction. That is also one of the issue needs to be gone into by the learned trial court.
Their case is that the daughters also inherited the tenancy.
Yes. So this is one of the vital issue which needs to be gone into.
Mr. Mukherjee, does it mean if you substitute them, you are accepting them as a tenant?
Lord, after this, Lord, word which trouble your lordship, Lord, I will have to also look into this because there are certain line of judgment. Today also I am carrying. Lord, 2G 5 years goes. This honorable court, even in appeal, is holding that no, the appeal got abated. There is no question of substitution. But Lord, I must say, Lord, this point has not dealt with. I have seen, Lord, I am carrying those judgments. Justice Mukherjee also delivered one of the judgment, Lord, holding that and both, Lord, where Lord, the lower appellate court has done that, said that 2G applies, so there is no question of substitution in tenants appeal. So appeal goes, come up in revision. Justice Mukherjee said it's perfect order and it's now a decree. So you have to come up in second appeal. But in none of these, Lord, this intermediate thing, what Lord is not being taken care of. So, Lord, I will have to, because there may be a class of difference that Order 22 Rule 4, this may not be a general way of substitution. I can restrict it saying that right to sue may not survive, but treating you as a intermediate thing, I am just placing your name in place and instead. I was under the impression once I do the substitution, then I am admitting that the right to sue survives.
Then, Mr. Mukherjee, in all cases of 2G, Administrator General has to be implicated as a party upon the death.
Because estate, Lord, no one will be there to represent the estate of the deceased.
That is the thing. But if someone is there, they may not have any right.
Right.
So, because we are allowing What is your ground? You have said that you do not have a right of tenancy. Your status is that of a trespasser. Even if you implead the daughters, their status will be that of a trespasser. If you file, let us forget about this.
But I am
You
not
file a
also
suit.
admitting
You
his
file a
possession.
suit for eviction of a trespasser.
I am not admitting her possession also.
Mr. Mukherjee,
Yes,
if
I
you file a
understand,
suit
Lord.
for eviction of a trespasser, if that trespasser dies, defendant dies, what you will do? Who will substitute? You substitute no one.
No, in that event, will not the right to sue.
So they do not become tenant. So
No.
their status, the heirs, their status is not elevated. So here, according to you, they were trespassers after the expiry of that period.
My case is of joint tenants.
How can it be after 2001? If when did Dhirendra die?
2013.
So how can it be? Both tenants after that period, both cannot inherit.
No, my lord. 2013, the original tenant died. My case is that the
You have granted receipts to both.
that my lord, I will have to.
Then
No. That is subject to proof. My case.
No, what is your
my
case?
My case is after the death of the original tenant, these two, widow and son, is joint tenant under me.
So you have accepted that.
Yes, I accepted that. That's why I say, my lord, opening my sentence was that I have accepted both of their tenancy as joint tenant. Both of them during pendency of the suit died. So my case is that the tenancy has come to an end. সেটা তো তোর ওখানে because your lordship knows the implied surrender concept. If they have not asserted their right, I file the suit, and it is them, Lord, who has contested.
And when did this both of them die?
Lord,
The mother, when did the mother die?
mother died, my lord. 14th of January 2025.
14th of January 2025.
And prior to that, son died.
Yes. So it's a joint tenant. So after that, daughters will be inherit up to 5 years.
But if it is joint tenancy, my lord, it's upon survivorship only.
No.
That is Kanji Manji.
2G says
2G, my lord, is a creation of tenants. 2G is a case.
yes, by virtue of 2G. By virtue of 2G, the daughters will become.
But my lord, 2G, my lord, it's always the tenancy in common, wherein, my lord, this law will apply.
That is,
My lord, that
Mr.
is the departure.
That is your creation. You are treating, but under the statute, so you are treating the mother also as a tenant, and who died in January 2025. 5 years, the daughters will become a tenant. Shall be allowed to continue in view of 2G.
My lord, then also, my lord, there is a rider. They will have to, my lord, living at the time of death of her mother.
Who is that?
My
Mr.
lord,
Mukherjee?
that is my, my lord, that is the trouble, my lord, I will have to undergo during the trial.
Whether residing, not residing,
no,
that is a.
my lord,
So by virtue of this,
there are
they become.
two way of thinking, my lord. First, my lord, if it is a joint tenancy, question of
Please think over this, because
I
upon the death of the mother, the daughters will be
in a tenancy in common always.
for
That
5
is-
years.
that
at
is
least.
always.
For 5 years at least. Even apart from 211. After some argument, Mr.
Both are similar.
24 and 28, same order. Yes, next. Against two tenants. Against two tenancies. Yes, next.
Two separate rooms. Lord, since my lord, the learned judge has directed me to substitute in the meantime, it's my suit ultimately. Stayed it for
There shall be an order of stay of all for the, then you have to serve.
without any opposite party. If your lordship direct not, I can serve Administrator General lordship.
No, Mr. Mukherjee, if you say that you will not serve, then you have to implead Administrator General. You cannot say, I will not implead Administrator General.
My junior will do that, my lord. My junior will do that.
What is your case? That Administrator General, when you say Order 22 Rule 4A, Administrator General has to be impleaded.
Proposed direct party, my lord, was there in my application.
Proposed direct party.
Yes.
Because that was rejected.
That was rejected. That's why, my lord, I cannot bring it, my lord. If your lordship gives me leave, my lord, I can do that and serve.
All right. That will be amounting to.
Yes.
The heading motion in the monthly list of July.
Only two matters, the ejectment suit number will change.
দুটোতে দেখে নেবেন 24 and 28.
I'm grateful.
Yes, I'm coming after 5 minutes.
In this matter, I am appearing on behalf of the petitioner. The National Textile Corporation, a public sector undertaking, is petitioner before your lordship. There is a dispute between two public sector undertaking.
What is the impugned order?
Impugned order is this. Notice of possession has been issued by the estate officer.
Public premises?
Yes.
Yes.
Against which appeal has been preferred. That appeal, unfortunately, due to eye problem, eye surgery, on that date, the learned advocate couldn't appear and it was dismissed on the ground of default. Restoration application has been filed. That is scheduled for hearing on 2nd of June. Till that date, this notice possession which has been issued by the estate officer, that should be stayed. And moreover,
apply before the appellate court. You have not made any prayer for stay.
Lordship, kindly come to page 16.
No, before the appellate court.
No.
You make a prayer before the appellate court for stay.
Practically, what happened? It was dismissed on the ground of default.
I appreciate that. You have filed a restoration application.
Yes.
That is registered as a miscellaneous case.
Yes.
So apply there. Not from here.
But that is on 2nd of June. The date has been scheduled.
You can file an application.
We are seeking protection from your lordship.
That is for hearing of that is for hearing of the miscellaneous case.
Yes.
So you approach for interim order in that miscellaneous case.
Obviously, on 2nd of June, we shall pray for.
I will give you liberty to approach there, not from here.
Lordship.
Yes, who is appearing? None appears for the petitioner at the time of same order. Next.
89.
29, my lord, I am for the petitioner, my lord. My lord, Mr. Chaudhary is leading in this matter, my lord.
Which Mr. Chaudhary?
Mr. Jishnu Chaudhary, senior
Yes,
advocate.
what do you want?
My lord, he is, my lord, on his legs, my lord. I'm only praying for not today, my lord.
On the prayer of the learned advocate for the petitioner.
I am for the petitioner, my lord. Now, my lord, I have a sanctioned building plan up to G+2. Thereafter, a mezzanine floor has been constructed. Now, my lord, your lordship knows, my lord, that my lord, under the Bengal Municipal Act, there is a provision if there is a minor deviation, they can regularize. I submitted a as-made plan. That was, my lord, pending for consideration. Now, my lord, your lordship knows, my lord, chairman has no power to decide this issue because board of councillor is a person. Now, my lord, board of council, the chairman, my lord, only without considering my as-made plan because there's minor deviation, my lord, one toilet and one thakurghar is there. Now, my lord, direction was given for demolition, my lord, without specifying, my lord, what is the portion of unauthorized or nothing that. I preferred, my lord, 218(3), I filed a suit. In the suit, my lord, first day, my lord, my injunction has been turned down.
Where is that? By which order?
But kindly see the order, your lordship will find the certificate copy, my lord. Last page, my lord. 25th April 25. Without considering the power and regulations, my lord. But the under the Bengal Municipal Act, there is a provision, my lord, they can regularize, my lord, if there is a minor deviation, my lord. And my lord, moreover, my lord, your lordship knows, my lord, this judgment, my lord, they have to, my lord, specify no inspection, nothing, my lord. No copy of the inspection report has been also supplied. But my suit has become infructuous by this impugned order. I have only one toilet and thakurghar, my lord. And that was constructed, my lord, long back, my lord. And on that day, my lord, I filed the, my lord, the as-made plan. Kindly see the as-made plan I have annexed, my lord.
No, where is the minor deviation being defined?
But if your lordship sees, my lord, neither in the Howrah Municipal Corporation, my lord, Kolkata Municipal Corporation, and there also, my lord, that the what is the term of minor deviation that has not been stated. It is a discretion of the chairman.
There is another notification, Mr. Mukherjee.
This is the current one. Subject to correction, this is the current one. Deviation, my suit has become infructuous.
Where is Mr. Probal Mukherjee?
My appeal has been admitted, my lord. In the suit, my lord, appeal suit has been admitted. And no interim order. That means amounts to, my lord.
Only because a suit has been filed, Mr. Mukherjee,
No, but not.
an interim order of injunction has to be passed.
Absolutely.
Show me the law.
Absolutely not. Absolutely not. But my lord, at least they ought to have.
Admittedly, there is an unauthorized construction.
Portion kindly visualize. But I have the sanction plan. Kindly see, it is not the case, my lord.
Show me that there is a sanction of the bath and privy and the. Then that is why I am saying admittedly. See, admittedly there is an unauthorized construction.
Kindly permit to serve copy, my lord. Kindly protect me for some time.
No notice of demolition has been issued now. When it is going to?
That's why, my.
Which municipality?
South Damdam Municipality.
Who appears for South Damdam Municipality?
HON'BLE is the junior. Ki naam or bhule achhe. Mr. Ray's junior appears usually.
Which Mr. Ray's junior?
Molesh Ray. Kindly keep it after vacation. Kindly grant me for
Call in, serve him a copy. Today or tomorrow?
kindly
Today?
keep it on Friday, my lord. Then
Friday?
I will serve, my lord, because my lord, when they will come, my lord, kindly keep it on Thursday.
Where is
Before-
Mr. Amolesra? Mr. Amolesra appears for South Domdom. Ask Mr. Amolesra to come. Passover.
For limited period, lordship can direct.
Yes, let me see what is the nature of the construction you have made.
31.
If Mr. Rai can appear, please serve him a copy and come. Passover Kora. Yes, next.
I may come at 2 p.m.
2 p.m., 3:30 p.m. according to your choice, Mr. Mukherjee. You can decide the time. Which time will suit you?
Whenever your lordship will direct, my lord. We are regard to appear, my lord.
Yes.
Copy this.
Yes, which item? 31, yes, Mr. Pine.
Item 31. My lord, opposite party herein, my lord, he filed a suit for declaration and injunction. My lord, dispute.
What is the order impugned?
My lord, order impugned, my lord, if your lordship kindly see, my lord. Last page, my lord. This is the order impugned, my lord. Page. No, last page. My lord, order number 120, my lord. This is the first order. Today is the fixed for further cross-examination of the learned survey past advocate commissioner. Hajira filed on behalf of the plaintiff. Learned advocate commissioner Dilip Chatterjee, who is aged about 72 years, is present.
So it was allowed, your application was allowed.
My lord, but my lord, I was shut off, my lord. I could not, my fear was, give me only one chance to complete the cross-examination. That was turned down, my lord. My lord, my lord, my fear is very simple.
Where is your application?
My lord, this is my application. All along he was present, but unfortunately on that date, he was bedridden, result of which, my lord, he could not attend in the court, and moreover, the learned.
You want to cross-examine the advocate commissioner?
Yes, my lord. Only one chance, my lord.
What happened on 11th of February? It was for argument.
11th of April. Adjourned.
February 2025.
That matter was adjourned. Matter was adjourned. Matter was adjourned.
This is my application.
32.
Mr. Basu is also online.
Yes.
My lord, I am big to appear for the petitioner.
Yes.
This is suit for injunction. I am the defendant.
Lord, I beg to appear for the plaintiff.
Why are you begging, Mr.
Suit for injunction. I am the defendant.
It's suit for injunction.
Man will always.
Yes, what do you want?
May I
Come back.
Ex parte injunction application moved.
No, there's a caveat lodged, Mr. Mujumdar.
No, there is no caveat, my lord.
Yes, yes.
There is no caveat. When we filed, there was
There's a
no
recording.
What? Please. Don't call Mr. Mujumdar. Don't call. There is an endorsement I filed.
Please go.
No.
There is an endorsement.
We don't want to get through that.
Please check up whether it's by the same person or not. Please check up.
It is an endorsement I find. From here I can see.
First volume.
Virtually-
Ask now say first volume. Back sheet
Virtually I
of the
can see. Virtually I can see, but physically I could not see it.
This is a caveat in respect of a different suit, my suit, which is prior in the point.
Yes, yes. Now I can clarify. Now I can
My lord,
clarify.
My lord, the petitioner. No, we will serve, my lord, but kindly take it up before vacation.
No, no.
But the grave
But kindly take it up.
by dint of this order, they are now trying to resume possession through police help. But this is unbelievable. Engaging hooligans, engaging lumpen elements.
দখলে আছে unbelievable.
No, nowhere.
No,
Nowhere.
Mr. Mojumdar, don't disclose.
May I just take your lordship? First,
Yes, it's a
first
hotly
suit has been
contested
filed.
matter.
Just
Can it
one,
be taken up before the vacation, or you want?
two basic.
So far as we are concerned, my lord, I can only indicate this. It's an admitted position that my clients are the tenant. There is no dispute.
No, not at all. This is a dispute.
They have a
This
prior-
is the dispute.
We are tenants, not now.
Kindly.
For the vacation.
No, I have just got an injunction, my lord. Their hooligans are my lord.
Cannot get it. Cannot get it, my lord. He is not the tenant. Kindly see who is the plaintiff. Who is the plaintiff?
Precious time. My lord, first suit is filed by my client, the petitioner before lordship. My lord, on 2nd of May, the suit was filed. When they
2nd
were
of May of this year.
Suit
Yes.
was filed when they were attempting to disturb my possession.
Put for declaration by landlord that I am the owner.
No, not at all, not at all. Then, my lord,
your suit is for
my
Madam,
suit-
kindly,
My
madam,
lord-
may I interrupt? May I interrupt? Kindly see who is the plaintiff.
I
Kindly
think
see
Mr.
who is the
Basi wants to
plaintiff.
submit.
Yes.
Yes, Mr.
Kindly
Basi.
see who is the plaintiff.
Plaintiff is the, my lord,
Please, let my lord check up. Who is the plaintiff?
Plaintiff is the
the
daughter.
daughter of the tenant.
Plaintiff is claiming through his father and he is filing a suit. Is there any cause of action in favor of the plaintiff? The trial judge dismissed the injunction appeal on the ground holding that suit is not maintainable.
Fine.
My lord,
112A,
Which volume?
volume
suit is not
1.
maintainable.
Suit is not maintainable.
You see who is the plaintiff and what he is claiming? He is claiming through his father. Father is not coming, tenant is not coming. Is the suit maintainable?
Order of status quo has been passed.
My lord, not only
That create disturbance.
it has been recorded in the order that they are in the settled possession. So, my lord, kindly take, my lord, this suit is not maintainable at the instance of the daughter.
Kindly see the order.
Yet this now a status quo order has been passed.
So,
No,
my lord,
that we are opposing. But
My
kindly come to
possession.
page 45.
My
Kindly
lord,
come to page
status-
45.
Where is
The trial court's
the
order.
cut to possession in the impugned order?
my lord, only
Kindly come
electricity
to page
bills.
45.
Only electricity
No,
bills.
on the basis of the electricity bills, is there any
At
finding?
whose name?
cut to
At whose
possession? Where is
name?
that?
Kindly take, my lord, page 112C.
At whose name?
Yes.
Name of the father.
The rent, everything,
surrender his tenancy.
electricity bill, everything is in the name of the father. The daughter comes and files a suit when we had already filed a suit against the father since they were disturbing with my peaceful possession. The earlier suit has not even.
I will request your lordship to see the trial court's order where it was refused. Kindly come to page 45, the trial court's order.
Page
45, trial court's order.
Trial court
45.
45. Yes.
Kindly see that on which ground it was rejected. Suit is apparently not maintainable.
এই তো রয়েছে।
Order, impugned order.
Caveat করে যে impugned order থাকবে না?
এদেরটা ওটাই করিস নি।
না, আছে, বুঝলি?
আছে।
There, in this matter, caveat is fine.
And the appeal court said it is a technical ground. Well, rescind order of refusal. Well, rescind order of refusal.
Yes, Mr. Majumdar, serve them a copy.
Yes, man.
I'll take up day after tomorrow.
Representing all the opposite parties.
And in the meantime, my lord, in the meantime,
Tomorrow I will hear.
tomorrow.
Malad, but tomorrow can it be at 2? Malad, I will be returning back, Malad. My own convenience.
Then
If
let
possible.
tomorrow, my lord.
Tomorrow.
Can it be at 2?
Thereafter, timing has to be adjusted.
Very well.
After
From now, fix the time because
tomorrow, my lord.
only two days, effective days.
Very well.
Very well, very well. What me, Malad? They all are here, Malad. Very well.
Mr. Basu assisted by Mr. Basu, senior advocate, assisted by Mr. Majumdar. Senior advocate appears.
After tomorrow, risky.
I could not follow. Next.
30 matters, 140.
But I am appearing on behalf of the petitioner. I am led by Mr. Siddhartha Banerjee and Mr. Parthopatim Roy. Mr. Siddhartha Banerjee is appearing online.
Yes.
Milord, I beg to appear, Milord, on behalf of the petitioner. Milord, the previous matter also, Milord, I was assisting Mr. Basu, Milord, I just could not follow, Milord. It's, Milord, returnable
Kindly
tomorrow.
record his name.
Yes,
Let him
yes,
answer,
sir.
No,
please.
tension no, na, sir.
Kindly record his
আগেরটা Mr. Majumdar Laner, senior advocate,
Sir,
assisted by Mr. Basu Laner, senior advocate, assisted by Mr. Majumdar, senior advocate, and Mr. Bennett.
And Mr. Bennett. He saved.
So it will be the body of the order, Mr. Banerjee.
No.
Memo of appearance in the body of the order also.
Milord, this is a very short matter. Milord, a suit for declaration and injunction. Milord,
Opposite party led by Mr. Mukherjee, Milord, is online.
Led by Mr. Probal Mukherjee, yes.
Online.
Yes.
Milord, I am asking for nothing against Milord Mr. Mukherjee. Milord, this is a suit for Milord declaration and injunction. Declaration to the effect that Milord the plaintiff is entitled to Milord charana of Milord the sand mining. My lord will kindly have a look at the plaint at page 62. Milord, he says,
what is the impugned order, Mr. Banerjee?
Milord, postponement of my application, Milord, under order 7 rule 10, one under Milord order 39 rule 4, the other one Milord under Bengal Agra and Assam Act. Milord, I say that Milord, this suit Milord should have been valued at 30,000 rupees, 30 lakh rupees, because Milord, the plaint proceeds on a basis that he paid me 30 lakh. And on the basis of that payment, Milord, he is entitled, Milord, to charana of the Milord sand mining. Kindly, Milord, just have a look at page 62. It's Milord 1.5 page.
Banerjee, did you file any application under section, I think, section 11 of the Suit Valuation Act?
Milord, I have not, Milord, captioned it as such, but Milord, I have not captioned it as such. Yes, kindly, Milord, have a look at page 81.
81?
Yes, Milord. Yes, 81.
Yes.
Milord, I have captioned it as an Milord application under Milord Bengal Agra Assam Civil Courts Act, where Milord I have said that Milord the suit valuation should be Milord at least Milord 30 lakhs of rupees, and Milord this should not lie before Milord the learned civil judge junior division. Milord, I am sure Milord my learned senior friend will not go by Milord the caption of the application. The nomenclature is nothing. What I intended to say is Milord what my lord is Milord
It has been done
suggesting.
by the impugned order.
Milord, the application has been postponed, and Milord, interim order they obtained ex parte, Milord, way back on 12th March 2025. And Milord, my 39-4 application on this point, my application for return of the plaint and for placement it before the appropriate court, those applications are not being touched. Now, Milord, because of the
Lordship will kindly see the last page of my lord's brief to find out Milord, the order that is
Sir,
under
আমার
challenge.
আর স্যার আমার আর 1.5 মিনিট লাগবে, আমি জাস্ট বলিনি 1.5 মিনিট লাগবে, তার বেশি লাগবে
Because
না।
you see,
Yes,
you
yes.
see the
Milord, I
impugned order.
want, Milord, an expeditious disposal of, Milord, my applications.
Say that
Milord,
in that event, then I will not be opposing.
yes,
You are
that's why,
saying that
Milord, at the very
you
inception,
are
Milord,
trying
I
to
said, Milord, I have nothing to, Milord, claim against Mr. Mukherjee's client. Milord,
say
my
everything is
application,
against my client. That is, I am the plaintiff. So what do you
Milord,
mean?
I am asking
Accepting
for
there are two
expeditious
parties, there are no
disposal.
other party.
Milord, that Mr. Mukherjee is not opposing, Milord,
Say
I am clear.
that I am
Yes,
asking for
yes,
disposal of the interlocutory
Mr.
petition.
yes. Milord, in a time-bound manner, in a time-bound manner.
That's the only
Milord,
one.
the suit is,
When an application has been filed, alleging
Milord.
that the suit is not properly valued. So
Yes, Milord.
the court has a duty to consider that because it
Correct.
goes to the root of the jurisdiction.
Correct. Let him, Milord, consider that, Milord, on the returnable.
I'll judge, consider that application on the next day.
Milord,
Yes,
today
that
is the
he
next day. Milord,
says so,
today is
Milord.
the date returnable. Today is the date returnable. Milord, let him consider this in the second of today. These are interlocutory
Mr.
applications.
Mukherjee, your junior says tomorrow is the date.
Oh, then, Milord, it's all the more better. Milord, it's even better.
So I'm directing this application to be considered tomorrow.
And to take a decision, Milord, on this
take a
application.
decision.
Yes.
And Lord, other thing is that Lord, if no written objection has been filed by my client, Lord, my client will file a written objection. But let him take up tomorrow. But Lord, after considering my written objection, the learned court is to dispose of this matter.
Absolutely, yes, Milord. I can't stand, Milord, in between.
Can you give an advance copy in course of this day of that written objection?
Lord, I do not know whether the written objection is ready or whether, Lord, there is a direction for a written objection. If your Lordship kindly comes to, Lord, the impugned order,
I can Mr. Mukherjee, I can give you liberty to file. I'm only asking you, can you file an advance copy of that same, or you can serve an advance copy of the same to Mr. Banerjee's client in course of this day?
Lord, today, Lord, it is not ready. Lord, I have to, Lord, keep ready, Lord, the written objection. Tomorrow is the date, Lord.
Let us have it, Milord, by tomorrow morning. Let us have it by
Your
tomorrow
Lordship
morning.
will kindly have a look at the impugned order. Your Lordship will understand, Lord, that there was no, Lord, direction for filing of the written objection.
No, Mr.
My
Mukherjee,
learned friend says that tomorrow there should be a hearing on his application, but without my written objection on record.
Milord, the applications were filed, Milord, long back. Milord, I need not wait for, Milord, a direction to put in my objection, Milord, if I want to object something.
Mr. Banerjee, that is
don't
one
let us-
thing, because it's your application for preponing the date of hearing. So it's an
Milord, I
application.
am not on that. Milord, that has, Milord, lost its force because, Milord, that date has gone, Milord, so, Milord, that application has become infructuous.
Banerjee, when you have filed an application, they are entitled to an opportunity to file written objection.
Absolutely.
So-
Let them file it by tomorrow, Milord. I will take it and I will get the matter hard, Milord. This is absolutely a law point. Milord, there is nothing to be decided on facts.
Mukherjee, I'm permitting you to file by tomorrow. Mr.
Yes,
Banerjee,
yes.
even if you file by tomorrow, you do not have.
Yes, yes. Milord will take it by
I
one
will
hand and
try,
Milord
but
will
your
argue
Lordship
the
will
matter.
not bind the learned trial judge that he must dispose of the application tomorrow.
No.
Lord, whatever, even if, Lord, if I go by the merits of Mr. Banerjee's contention, which I am not before your Lordship, his contention about the content of the plaint should have been valued more than 30,000 rupees.
30 lakhs.
30 lakhs rupees.
Mukherjee, only one thing, in an application of this nature, what the learned court is required to do is only to go by the reliefs claimed in the claim and how the
Correct.
claim. So, filing of a written objection, since you are insisting, I'm providing for that. But you have to rely only upon the statements made in your plaint and nothing more than that. And only the top points under which provisions of the Court Fees Act it follows, you can only rely upon that and how the suit valuations have to be, provisions have to be applied to the case on hand. So
My
it's,
lord.
you cannot improve anything by way of a filing of a written objection. Whatever point you will be raising, the rules will be the legal issues, which you can very well raise at the time of hearing of that application.
Very well. Now, Lord, there is another point. Mr. Banerjee was submitting that his application under Order 39 Rule 4 is also pending. But I do not find from the impugned order, my lord, something of that nature is
I am
pending.
only directing this this
My lord,
application.
let us
But
thrash
the
out, my
time
lord,
see
the
the last
application.
impugned order, he cannot improve upon his case by, my lord, his oratory. Because whatever that
Very
is
well,
there
my
on
lord, I
record, my lord, that
restrict
should be
my
there.
Mr.
very,
Mukherjee, I am
very
only
well. My lord, I
directing.
restrict my prayer to the hearing of my application on the, my lord, suit valuation part
that.
So
today.
you
Only
should have
that
said it at the first instance.
Yes, Ashun.
স্যার আজকে আমার বড্ড বকছেন
No, it's not that.
This matter was where is the plaint, Mr. Banerjee?
Plaint is at my lord from page 62.
Page 62, minute, page 62.
Page, is valued. Mr. Banerjee,
Yes, my lord, yes.
page 80, no, sorry, page 80. No,
My lord, there are two applications. My lord will kindly take, my lord, page 83.
83 is the composite application.
83.
80 is the application for preponing which was dealt by the
Right.
impugned order.
Correct,
There are two
correct.
Lord substantive applications only, one under
81 and 83.
81 and 83
Yes, yes, yes.
তাহলে ওই দুটো কি বললাম ইন্টারেস্ট না কি বললাম দুটো অ্যাপ্লিকেশন করবেন একটা হচ্ছে 107 রুল 10
92 Bengal Agra.
led by Mr.
Banerjee. Mr. Banerjee. I am led by Mr. Banerjee.
Yes,
Well,
Milord.
Mr. Banerjee.
I am
Yes,
led by
Milord.
Mr. Banerjee. He was online, so I am physically
Wait,
online. Last order passed by the learned trial court.
Yes, what is the last order?
Mr. Mukherjee submitted that no object opportunity was given for filing written objection already. Object.
Oh, Mr. Mukherjee, you have been given opportunity to file written objection by the order dated 16th of April 2025.
পার্থদা ওটা যেহেতু রেকর্ডে মানে আমাদের রিভিশনাল অ্যাপ্লিকেশনে ফাইল করা নেই তাই স্যার বলছিলেন যে ওটা তো এখানে রেকর্ডে কোর্টের
Mr.
সামনে
Mukherjee,
আসেনি
you have been given opportunity to file written objection in the meantime.
Well, that is by a subsequent order, which is not the subject matter of challenge before your lordship. The subject matter of challenge is 20th of March order.
That is a different thing. The opportunity to file objection is there. You have been given
Yes,
opportunity.
yes, Lord, that is there. Lord, all that I say that since your lordship is directing hearing tomorrow, Lord,
Yes.
I need to ascertain whether Lord, the written objection has been filed or on record or not.
All right,
If not, kindly give me an opportunity to file a written objection.
Yes, yes,
And
yes.
that should be confined to Lord, two applications. I don't find any application under Order 39 Rule 4 in the civil revision
No, no, no,
application,
I'm not
which Mr.
directing
Banerjee
order
was talking
39
about.
rule 4. I'm not directing order 39 rule 4.
Lordship.
Interest of justice.
Ballot 21st. If the type, otherwise, I am suffering.
Expeditiously, Mr. Rai, I have said, please don't put undue pressure on the judicial.
Asking for
difficult. I do not know the diary of the learned trial judge.
And even the Supreme Court has said in the recent decision, Lord, that.
Mr. Rai, it's difficult. You convince the learned trial judge. You have to apprise of the learned trial judge of the urgency. If that is done, I think the learned trial judge will fix a short day.
May I get the survey copy today? Because tomorrow, my lord, we have to file.
Present. You can communicate that order.
That may be done so you can
lawyers communication.
As good as
yes, yes. So you know all this. Yes.
Grateful, brother.
Grateful.
139.
Yes, yes. Please wait, Mr. Mukherjee.
My lord, this matter, my lord. Well, if you lord sincerely see the impugned order, my lord, I have made an application in execution, my lord, on 150 on CPC, my lord, for identification of the property, my lord.
Identification of
the property which has been degreed, my lord. so that the degree can be executed. My lord, they are what by the guise
You
of.
cannot identify the property.
No, I am identifying what they are trying. They are trying to grab my property, my lord. This is my
Degree is passed in respect of another property.
other property. My lord, I will show from this petition, my lord. I have filed an application.
Let us see what the bailiff, let the bailiff go and find the report.
My bailiff was there.
See whether the bailiff can identify the property.
No.
That I will
My
consider.
lord, what they are doing, my lord, they are trying to grab my property in the guise of the decree for execution of the decree, my lord. My property, that number is.
You apprise the bailiff at the time when the bailiff will
My lord,
go.
Can you see the
Possession, that this is the different property, that is my property.
my lord,
It does not.
bailiff is not hearing me, my lord. Kindly see the impugned order at page 2, my lord.
Bhattacharyji, were you a party in the suit?
Yes,
Did you take this point in the suit with regard to identification of the property?
my lord, there the suit was, two suits were filed. One suit I filed
I'm
for
asking you the decree which you are assailing now,
my,
or the execution.
my lord.
Were you a party in that suit? Did you
Yes.
take that point of identification in the suit?
My lord,
How it was decided?
my lord, now I am telling
Did
you,
you take yes or no?
no, because
If you have not taken, end of the
No.
matter.
my lord,
Be open
kindly
now.
see, my lord, the suit was for eviction of the tenant. That degree has been passed in respect to certain property. Now, my lord, I have purchased another property nearby the property of the decreed property. Now, in the guise of that decree, my lord, they are trying to take possession of my property.
Where is your property and where is the suit property?
My property, my lord, I have stated
I
in
will restrict that the bailiff will take possession only in respect of the decree.
decreed property. Yes, that I want, my lord. Kindly, my lord, kindly see,
Has
my
the
lord.
executive court directed to take possession of any other property?
No, what executive court says, my lord,
Yes.
that since earlier I have made an application under order 26 rule 9 for appointment of the.
Bhattacharyji, you need not be apprehensive because it has been said bailiff is directed to break open the padlock of the decretal property.
Yes.
As per the read.
Yes.
So you are not affected.
They are
Other property.
My lord, but they are coming to my house, my lord. That my lord, kindly sees only one line, my lord, at page 2 of the impugned order. Kindly sees, my lord. Court admittedly, my lord, held, my lord. Kindly sees, my lord. Kindly, my lord, third paragraph. Kindly sees, second page, my lord. Now reverting the facts of the present dispute, my lord, has your lordship got it, my lord? Second page, my lord.
Second page. Yes, I am on the second
Second page, my lord, third paragraph.
Yes.
Leaving first two line, then my lord, third line. Here, admittedly, the property in connection with of which the judgment debtor have prayed for relief is not the decretal property and have even no connection with it.
Yes.
The court's finding, but ultimately my application was rejected on the ground that I have earlier taken a stand under order 26 rule 9 for appointment of surveyor commissioner, my lord. That's why this application was rejected. And my lord, prayer is that, my lord, my property should not be, my lord, taken over by the.
No. The police will only, the bailiff will only break open the padlock of the decretal property.
That's why, my lord, why I am saying this, my lord. Otherwise, the property, unless it has been identified, my lord, by the court, my lord. Now the bailiff came and come to my house. My property was, they have taken, my lord. They are trying to take, my lord. That's problem I am facing, my lord.
They will only, I will only direct that only the decretal property.
My lord, thing is that, my lord,
The property, only the decretal property.
all are adjacent.
That is the
in
different thing.
Asansol, my lord, kindly see, in Asansol area where they are residing, my lord, very small portions are there, my lord. They are constructing their houses. Now, my lord, my houses, they are trying to break open my houses, lock up the houses, and trying to.
If it falls within the decretal property, it cannot.
No, I not, my lord, kindly see the degree, my lord. Kindly
That
see.
cannot be decided from here, Mr. Bhattacharyji.
My lord,
Asun, this application under
identify the property.
bailiff will go and find this application.
Lordship mention one.
I've said only decretal property.
Only dark number kindly mention, my lord. My dark number is there, my lord. My lord,
Decretal property, I think that will end everything. You are not in the decretal property. Dark number and other thing I cannot ascertain from here. Yes, call the next matter.
210.
Yes. Yes, where is Mr. Mondol?
Yes, is there.
Oh, you are appearing.
Mr. Mondal is reading me.
Yes. You are opposing.
My lord, although there is no caveat, my lord, I have just received a copy of the application today.
You are ready or you are unready?
My lord, I am not ready. I have just received the copy of the application.
There is no caveat. He paid for the same. I have handed over a copy.
What is the order impugned, Mr.?
Yes, my lord. Can you turn to the order impugned? Mr. Mondal is represented by Mr. Chakraborty.
Mr. Mondal is
represented by Mr. Chakraborty.
Yes, yes.
Go
Yes.
Align section 7.3.
Align
Section 7.3. Order
if there is non-compliance of
yes.
7.1 and 7.2.
My lord, can you turn?
It's automatic, Mr. Rai.
Yes, certainly. No problem. If you lordship, can you turn to the order impugned once?
No, according to you, you have complied with 7.1 and 7.2.
Received summons on 7/10/2023.
Received summons on 17/10/2023.
10/2023.
Yes.
And on the date of appearance, 8/12/2023. It should be, it is wrongly.
It should be 2023.
It should be 2023. That is the date of
Fixed, after 1 month.
Yes. 7.1 I did not comply, so with beyond 1 month. Whether
7.2.
7.1 and 7.2 both filed. So if I unable to comply with 7.1 within 1 month, then there is no question of getting entry into the 7.2. Am I clear to your lordship? Well,
7.1 and 7.2 are different things. Have you disputed anything?
I have disputed. My lord, Kali consider I have disputed.
What is the dispute you have raised in 7.2?
7.2 is the area of red.
What is the dispute you have raised in 7.2? If there is no dispute, 7.2 does not apply. Where is the dispute?
If your lordship can turn to page.
I'm asking you, you can tell me what is the dispute? Rate of rent, period of default. What
period
is
of default? Period of default.
So rate of rent is not in dispute. Have you
deposited with the rent controller?
You are depositing with the rent controller. Till the last date.
Till the last date.
So according to you, there is no default.
Default. But for the purpose of participating or continue with the current deposit, I have to file an application under section 7.1.
Yes.
7.1 postulates that within 1 month.
According to you, 7.2 was not necessary.
7.2 is not necessary. Apart from that, whether I have any doubt on the mind of the court for not filing the application within 1 month, whether it is mandatory or directed in nature.
What? 1 month?
1 month. The proviso which is there 7.2.
After 7.2, 7.1.
7.1 in the proviso 7.1 also it will apply. The Honorable Apex Court said.
No, it has not been decided now.
May I read out
for the reference now. These decisions will be considered now. Amit Kumar Chamaria, Debashish Pal.
No, it was considered. Amit Kumar Chamaria considered. After that, the ratio which is laid out 2024. Volume 2 Supreme Court case is 169. I have only one copy. I handed over to your lordship. Placing the same.
It has been decided.
My lord, may I read? We have no doubt over the proposition that so generally the Limitation Act is applicable to provision.
Where is that decision? Give me the decision.
2024 Volume 2 SCC page 169.
169.
You are having only one copy, Mr. Rai.
Just now I get it. No, এটা নিয়ে এসছে paragraph 60.
That is Debashish Pal. After that, there is a reference before the Supreme Court. Debashish Pal, you are relying upon paragraph 17. Paragraph 18 says another thing.
Paragraph
Now,
18, one can consider paragraph 18.
Yes.
Here
Kindly
also
come to
larger
paragraph
context.
18. Kindly come to paragraph 18.
There is also larger context in this behalf as the Tenancy Act provides for certain protection to the tenants beyond the contractual rights. Thus, the provision must be strictly adhered to.
Yes.
The proceedings initiated on account of non-payment of rent have to be dealt with in a manner as tenant cannot occupy the premises and not pay for it. This is so even if there is a dispute about the rent,
The tenant is thus required to deposit all areas of rent.
So here there is no dispute with regard to the rent.
My application
Here there is no
is
dispute.
not considered.
Mr. Rai, here there is no dispute. In your case, there is no dispute. Here it has been said, even if there is a dispute, you have to comply with, as this time limit has to be complied with.
Yes, that is.
First. Second is, where is the subsequent decision of the Honorable Supreme Court, wherein this is being considered?
It is referred.
Amit Kumar, yes.
Referred.
What was the issue there?
Here the issue whether this time limit 2 months
For what?
for the date of appearance or deposit the along with all the areas.
Show me that issue.
No, that is why, my lord. Can you consider the why the
With the issue which is pending consideration before the Honorable Supreme Court.
that is also pending with your lordship. My lord also considering the same, my lord. Now, my lord, that is why. What is the time limit for filing 7-1? This is a concession with the trial court for rejecting my application. I could not understand that my 7 was considered and rejected some other grounds. That I filed this application after 1 month from the date of receiving the summons. Whether that is a sine qua non for entertaining my application under 7-1. Because that is the date of appearance. I received the summons. Beyond 1 month, there is direction for the summons date of appearance. Whether this extension can be applied to 7-1, which is there in section 7-2. I am on the presupposing this judgment as on this day that there was this fall that yes, the proviso is mentioned in 7-2 will apply also 7-1. Then also I get that extension period.
Extension for?
For consideration of my application under 7-1.
Where is the scope of filing an application under 7-1?
7-1, my lord.
Where is the scope of
Yes.
filing an application under section 7? You have to deposit that amount.
But deposit can be made under the CRO.
That you have,
My lord, I am conscious about the fact, my lord, CRO, my lord, provides that it should be passes to the Cesar.
that is a different thing. It does not require, Mr. Rai, it does not require. It's a challan which is to be passed by the Cesar.
Challan, where is the challan? The deposit, why you have challan?
Yes.
Challan to be passed.
So, no, yes. So show me your challan that you have placed it. Where is your statement that you have placed the challan before the Serestadar and the Serestadar has not allowed you to deposit?
Opening day, I file an application that you allow me.
There is no scope to file an application, Mr. Rai. You have to deposit the money. So, bona fide. On that date, you have to go. Maybe if you are banking upon that proviso, then you have to approach this court, give me permission to deposit.
Precisely, was as you did 7-1.
The application with the money.
I'm ready with the money. Till that period, I have deposited entire money with the rent controller before the appearance.
Yes, sir. What do you say?
My lord, as has already fallen from my lord, Chamaria's judgment is staring at us. My lord, Chamaria's judgment as well as my lord's judgment is staring at us, my lord. And admittedly, my lord, 7-1C, as I have briefly glanced through the brief, he has to continue paying the rent. As I have briefly glanced through the rent control deposits.
What do you say that the proviso after section 7-2 shall apply also to 7-1? 7-1C also. What is your reaction to that?
My lord, kindly allows me to come back once on that issue. 7-1C has not been complied with, that I can demonstrate. 7-1C to continue paying with the.
That is why he is saying that when he applied, according to you, it was not within 1 month. According to Mr. Rai, he is entitled to 2 months.
Extension 2
months. As per the extension of 2 months, as per the proviso appearing after 7-2. According to him, it also applies to 7-1C.
My lord, what I'm trying to indicate, once the area
Mr. Rai,
of
where is
rent,
your application under section 7-1?
Page 40.
40.
Page 48.
48.
No. Actually, this is 7-2, 48. পরে আছে পরে
This is 7-2.
Yes, madam. 7-1,
7-1.
52. Paragraph 5, page 53, paragraph 5.
This was filed when?
On the date of appearance?
No. Please give me the date.
Yes. Date of appearance, madam, I have 18-12, subject to action, madam.
18-12.
18/12/2023, subject to correction, my lord, may I? 8/12/2023.
So, and till November you have deposited, where is that statement?
Paragraph 5, your lordship find?
No, no, no. Where is your statement that you have deposited before the rent controller till November?
If your lordship kindly turn to paragraph 3, that the plaintiff has alleged that the defendant is a defaulter in payment of monthly rent of the property since April 2023. My lord, got it? Page 52, paragraph 3.
Yes.
Last, the facts remain that the defendant did not make any default in payment of monthly rent suit property since April 2023. As such, he has paid monthly rent of the suit property to the landlord rent collector from till December 2023.
So till December you have deposited.
Yes.
So
that,
from January.
Yes.
And
still now I'm depositing with the rent control.
So, if it is from January, Mr. Rai,
I have to file
then,
that application.
You are not in default. You are within time because this was arrears. You are saying there is no arrears.
There is no arrears. So current.
So current. So if you have filed an application in December and your case is that from January because you have stated that till December you have deposited.
That is why my lord,
there are two contradictory statements in your application. One is saying from December, and in paragraph 2 you have said till December you have deposited.
Till December.
So till December. So it should be from January.
That is why the prayer. My lord, that's the prayer.
Prayer, what is we have said? That is also from December.
So it should be January. I have deposited. It should be January.
So it should be January, then there is no default.
Yes, but for the purpose of current deposit, I have to get the permit.
Current deposit, Mr. Rai, current deposit, there was no default. There are two things. One is 7(1)(c), that 1 month from appearance is for the admitted arrears, is the arrears. So if according to you, there is no arrears, admitted arrears, till that date. So you entered appearance in December 2023. According to you, till December 2023, you have deposited before the rent controller. So now 7(1)(a), which requires deposit of admitted arrears, you are not on that. So you are on 7(1)(c). So 7(1)(c), according to your case, will start on and from January 2024.
Yes. But I have filed the application.
So you have filed the application prior to that. You need not go to the proviso even.
But
you
it
need
is
not go
said,
to the proviso even.
my lord is thinking is filing of the application under section 7(1). I am bowed out to your lordship because I have
not 7(1)(a). I am on 7(1)(c). Yes. So if there is no dispute, Mr. Rai, rate of rent, there is no dispute.
May I check it up? So far. No, you
said there is no dispute. It started with that. Now you are checking up.
No. Para 5.
No dispute.
No dispute.
Paying more. I am paying more. That is paragraph 5, page 49.
Is that dispute, yes or no?
Because I am paying, according to me, I am paying more. My rate is much less. That is the dispute. I have mentioned. So
you are paying
excess amount.
You are paying excess amount.
So this is the dispute.
But so there is no admitted arrears. If that is so, and but the only difficulty is with regard to the time limit.
Yes, that is precisely the thing. Time limit. Whether I am entitled to get that extension period for consideration of my application.
Whether that will apply for belated filing of 7(2) or
7(1)
for deposit.
Yes.
Mr. Rai, there are two things. One contemplates deposit along with an application. And it has been held section 5 is not applicable. If it is only deposit, you can say because proviso deals with only to deposit. So 7(1)(c) and other things only requires deposit. You can say if that applies, so you can be permitted to deposit. But this, whether it can apply to condoning the delay in filing an application.
What is the intent? That is section 7(1).
Yes.
7(1).
Even if the proviso is applicable.
That is why one of the honorable episcopal says 7(1).
Give him a copy.
Yes, I have already given you.
So I am posting it after the vacation.
Well, in the meantime, 7(3) allowed.
So I am staying the further proceedings of the suit. Yes.
My lordship, kindly consider, my lord, few minutes ago, my lord, I have received the brief, so I'm praying for 1 day accommodation, my lord.
You are praying for 1 day accommodation.
Kindly keep it after vacation, my lord.
Why? 1 day accommodation, you cannot wait for 1 day, Mr. Mukherjee.
My lord, there are other opposite parties also, my lord.
That I will consider. Other opposite parties is the complainant.
No, my
Other
lord,
opposite parties are the complainant.
there are two things, my lord, there are two things. My lord, if your lordship consider once, my lord, that 31 2B, my lord, permit under the West Bengal Municipal
All right,
Building.
I will consider. I will take it up
My suit has become infructuous, my lord.
tomorrow. Your suit will be revived tomorrow. Have you given her a copy? Hard Mr. Mukherjee Laner and
If it is goes down, my lord. If it is goes down,
will you allow the matter to go down?
Your lordship, seat after 2.
এই দেবাশিস পালের জাজমেন্টটা মিস্টার পার্থপ্রতিম রায় দিয়ে দিলেন।
your lordship's judgment is also there, my lord. West Bengal Handloom. There, my lord, your lordship consider all this. Mr. Aniruddha Chatterjee appear in one side, my lord. Section 5. West Bengal Handlooms, my lord.
What?
This point has been already been decided.
Thereafter, the Supreme Court now has referred that issue because
Against your lordship judgment also SLP filed.
yes, yes, 2 p.m. I will be sitting. That much I can say.
May I please, Lordship? Lordship, in respect of item number, serial number 26, Lordship, I was supposed to appear in this matter, Lordship. Due to late running of trains, I am late, Lordship.
What has happened?
Dismissed for default, Lordship.
Yes, sir.
প্রথম item
Original site item number 1, special asset number.
May I appear for the
Yes,
I appear for the High Court administration.
Gustav, please use the microphone.
The short question is not whether the disciplinary authority has issued the charge sheet and suspension order to me.
Issued the charge sheet and the suspension order?
To the writ petitioner.
Yes. What are you challenging?
Not the suspension order and charge sheet.
You want quashing of the suspension order? On what ground?
Having been not passed by the disciplinary authority or the competent authority.
Yes. Where is the order of suspension?
Please come to page 16.
1-6. So Gupta, you have instructions.
Yes.
You have received instructions.
My lord, my first point would be that the charge sheet, it is apparent from the suspension order as well as the charge sheet that it has been issued by this honorable court.
All right, I will hear. I'm asking you, you have instructions.
Yes.
Let Mr. Majumdar place his case.
My contention would be that this is premature.
It's premature.
Yes.
All right.
No, I'm not. Please come to page 16.
What is the interim order, Mr. Majumdar, you are seeking?
Not if the
Because if you are paying for quashing, if it is not on the face of it, then it is to be hard. So what is the scope of any interim order here?
event of the charge sheet having been issued without authority, then there is no scope of proceeding with the inquiry.
So your prayer will be for stay.
Stay of the inquiry proceedings. In course of the inquiry proceedings, on having put a particular cross-examination to the first witness of the management, the administration, the witness answered that it was placed before the Honorable Chief Justice. I'm not High Court. What is the meaning of High Court? That's the sole question to be answered by your Lordship on the judicial side.
All right. Yes, suspension order is at page 16.
16. Whereas you as a member of West Bengal Judicial Service, now posted as District Judge Jhargram, intentionally, deliberately and without any valid reason violated the order dated 19th of May 2023 passed by the Honorable the Chief Justice, which was communicated to you through court's letter dated 20th of May 2023 while you were posted as District Judge Purva Medinipur. You refused to hand over the charge of the office and court of the...
You are challenging now, Mr. Majumdar, it's of 11th of September 2023.
This surfaced only during the course of cross-examination in the month of April 2025.
No. This order was served upon you long back.
Right.
So cause of action arose in September or 1 or 2 days after that.
The fact that it was not issued by the Honorable High Court surfaced during cross-examination.
All right.
Now, the first two paragraphs is not the allegation, not of course relating to a different district. Be that as it may, the administration has thought it fit to place me under suspension while I was acting as a district judge in another district. But the normal rules of or the prerequisites of suspension, although not very strictly applicable in a case of this nature, still not the administration has taken a decision. Please come to the third paragraph.
Yes.
Or the last paragraph. And whereas your activities as mentioned above as a whole on your part is also one which amounts to gross illegality, gross misconduct and tends to violate the judicial discipline and decorum as an officer of West Bengal Judicial Service, and the same will necessitate disciplinary action against you. Now therefore, the Honorable High Court is hereby pleased to place you under suspension with immediate effect, asking you to submit written statement of defense in response to the articles of charge within 30 days from the date of receipt of the charge memo, articles of charge and statement of imputation as prepared under clauses B of sub-rule 2 of rule 11.
So Mr. Majumdar, as it appears from a bare reading of this, it says Honorable High Court has been pleased to place you under suspension. It's not, as you said, anyone else. It's the Honorable High Court.
Now, not Honorable High Court, the expression High Court has not only been explained in the Constitution of India, but also not within the parameters of our rules.
Yes.
Now, not it so appeared during the course of cross-examination that her matter had not been placed before that court at all.
Mr. Mojumdar, evidence has to be read as a whole. Can you pick and choose one line of an evidence and apply that for quashing of a proceedings, which on the face of it says High Court, Honorable High Court? There are two ways.
It's
on facts, if it is considered, after considering, it may be one thing. But whether at this stage of this quashing, whether it can be at this stage, when according to you, it has one witness have been examined and he has said something in cross-examination.
No, whether
can that be a ground for cross-examination, quashing of the suspension order or the charge sheet, whatever it might be?
This squarely applies in cases not where the authority is identified.
Yes.
Same not in a disciplinary rule, an executive director is empowered to initiate proceeding against a particular level of officers. But here is a case where High Court has been explained in a particular manner.
Yes, yes.
Not only with reference to suspension and posting, but in a different manner so far as
according to you, Chief Justice and High Court is not the same thing. That is your submission.
And disciplinary action vests in the High Court.
Yes. So that is your submission, but it appears from this, it has been said, Honorable High Court.
Right.
But you want to draw your analogy from some statement made in the evidence. Then it requires hearing, Mr. Mojumdar, because the evidence has to be taken as a whole.
The administration may place on record its stand that it was placed before the High Court. The decision has been taken by the High Court. Because it's a jurisdictional issue going into a fact.
Also, charge sheet, that is your point. Where is that? Charge memo?
It starts at 18.
Starts at 18.
Yes. Pursuant to the direction of the Honorable High Court.
Yes, it also says High Court.
A copy of the article and statement of imputation under rule so-and-so, including a copy of the list of dates so-and-so, in contemplation of disciplinary proceedings initiated against so-and-so by the Honorable.
Where is that evidence you are saying that some admission
63.
is there in the evidence?
Page 63.
Yes.
The first two questions.
First two questions. Answers are vague, Mr. Mojumdar. It does not say neither here nor there. It neither supports your case nor supports the case of the administration. On this, how can you
Kindly direct the administration to.
That is a different thing altogether. That is a different thing because first answer is I have no idea. Second is the administration can say this. So
Administration.
there is no admission as such.
The register administration was deposing.
Mr. Mujumdar, that is neither here
Very well.
because
That
you have sufficient experience
No,
while
he might not
conducting
have,
this.
he might not have personal knowledge on the date of deposing. So let
Yes.
the administration come up with its stand.
And you know how these witnesses depose, what are the statements to be made, that is the other thing.
The Registrar Judicial Service was deposing on that date. That was the deposition of Registrar Judicial Service. And the Registrar Vigilance has also started deposing.
Yes, Mr. Gupta, what is your
Will there be a
primary reaction to Mr. Mojumdar's submission?
there be a parallel inquiry by this court as well as by the disciplinary authority?
No.
No, I could not
The
follow.
question is,
Yes.
if he contends that this was charge sheet and the suspension order were not issued by or placed before the full court, that is a matter to be substantiated by him. This point he is taking. He has to substantiate it.
Yes.
During the proceeding. Now, in the proceeding, this is not the sole witness.
Yes.
Not the sole witness. Therefore, the evidence is expected to come at proper time. Therefore, my learned friend cannot expedite it by saying that as till now it has not come. Therefore, I ask the administration to produce this evidence before this honorable court.
No, that's not my argument.
That otherwise,
Not my
what
argument.
it is.
No, it's not my argument.
Mr. Mojumdar, in a way, Mr. Gupta has a point. whether
Today,
at this stage,
no, no, no.
a party can be asked to disclose their defense
No, no,
at
it's not a
this
question
point of time
defense to what?
when a inquiry proceeding is
Not,
pending.
let us not think it logically and not apropos the principles of service jurisprudence. The inquiry officer acts as a delegate of the disciplinary authority. He cannot decide on the aspect of jurisdiction of the disciplinary authority. Let there be no second thought on that. There cannot be any second thought on that.
That's not the issue at all.
Now, the question is,
There are two things. One is that according to you, this inquiry proceedings as well as the issuance of the charge sheet are without any authority. Prima facie, if you
no, I say not the inquiry proceeding. I say the order of suspension and the initiation of
charge memo. If the charge memo goes, everything subsequent goes. So according to you, this was by an authority who is not authorized under the relevant rules to take that. So prima facie, it appears from those two documents that those were issued by the appropriate authority on the face of that.
The order says so, but in cross-examination, there is an evasive answer.
Yes, in the cross-examination, there is an evasive answer. There are two issues on this. So inquiry officer, you can say that whether the inquiry officer can decide on the jurisdiction of the disciplinary authority.
He cannot.
That is one thing. But you will be having your opportunity before when the matter goes before the disciplinary authority. No. That is one aspect. Unless you can prima facie show from the basis of the materials that they lack jurisdiction.
Or even during the stage of the inquiry proceedings, when all the witnesses have deposed, cross-examined everything, from there it appears that the matters were not placed before the full court. It was not the decision of this honorable court, but of one honorable judge, maybe the honorable chief justice. Then, my lord, he has a cause of action. Until that, there is no cause of action whatsoever. That stage has not yet been reached. The evidence, it's not a question of the inquiry officer determining the jurisdiction of the authority. No, it's not that. The evidence has to come before him. If the evidence comes before him, it is for him to decide whether the charge sheet and the suspension order had been issued by the authority which under the rule is entitled to do. That stage has not yet arrived. There is no cause of action today.
That will lead to a fallacious position in the sense.
Mr. Mojumdar,
what will the disciplinary authority ultimately decide? The propriety of the finding of the inquiry officer vis-a-vis the materials collected in inquiry, he will not decide upon his own jurisdiction.
He may not. He may not.
Mojumdar, the inquiry officer, as you are right, cannot decide on the jurisdiction of the disciplinary authority. But what for this inquiry officer is being appointed? Appointed by the disciplinary authority. Disciplinary authority can on its own act as an inquiry officer, can carry on the inquiry proceedings.
He's a delegate.
But there are cases where an inquiry officer is being appointed to conduct the inquiry proceedings. The report will be placed before the. So these are the two things.
I am not questioning at all. Not his.
So now you have your opportunity if you raise this, because what you are trying to say is you are trying to make out your case of jurisdiction by relying upon some evidence. It's at the premature stage, because I do not know. It's only how many witnesses you have, Mr.
We have said that we have named two witnesses and
in the list of witnesses, two witnesses.
So, two witnesses named.
Yes.
And then it says that other witnesses may also be.
So at least two.
At least two.
At least two. And how many witnesses have been examined?
Only one. One is.
Second going on.
Second is going on.
Let us not dwell on this issue.
Because
today it's a question of lack of authority of the disciplinary authority. No witness can improve on this position.
Yes.
It's a question to be decided on the judicial side alone, not on the administrative side of the court.
Yes.
Today,
Mr. Mojumdar, it's not when the matter has approached before on the judicial side, it's not that it is to be decided by the administrative authority, administrative side of the High Court. It's not that. It has to be taken on the judicial side. The issue is, let us forget that it's a matter of the High Court. Let us now take a hypothetical case when your case is that you are whether this authority, the disciplinary authority, if you can put it, can be asked at this stage to disclose their defense.
No defense to what? Defense to charge.
Yes.
What can be a disclosure of defense?
What was your reply to the charge memorandum?
Not for the timing. I shall come to that.
Did you take this point?
No, because I come to know of this fact only at.
So at that point of time also, this was
I
not your
come to
case.
know of this at a later date. I
So
relied on
the,
the face value of the document.
yes, so evidence, yes, you proceeded on the face value of the document. So in the defense to the charge memo, you have not raised this point. Only your cause of action to raise this point arose because of two answers by one particular witness.
Or not say not even at this belated, suppose not there is no cross-examination put to a witness. At this stage, I come up before your lordship, questioning the jurisdiction and authority of the disciplinary proceeding authority to initiate a charge sheet. I am questioning the authority. Not the authority has to now disclose that very well. I have taken this decision at the appropriate level to initiate this proceeding. Kindly examine this on the judicial side. Kindly call for an affidavit from the High Court administration.
Milord,
The disciplinary authority will not be in a position to decide on his own jurisdiction. So, so will not the inquiry officer be?
No, why cannot the disciplinary authority
Because
decide?
One cannot.
Disciplinary authority can
He can
decide.
only decide whether the
You can say the inquiry officer cannot. Why not the disciplinary authority? You can very well raise the issue of jurisdiction before the disciplinary authority
when I'm raising
at an appropriate stage, or maybe at a prior stage when the inquiry.
question raised with regard to authority and jurisdiction of the disciplinary authority can be raised at any stage.
Yes.
It's not a question of an appropriate letter or.
There are
primary
two things. One is prima facie. It's there.
So prima facie, it
What?
may not be a position.
Prima facie, there is nothing.
It may not be a
So
suitable
where
case.
is your Mr. Mujumdar? Before asking them to disclose their stand, what materials you have to first make out a case because you have approached the court.
Right.
Show me what materials you have,
Only page
accepting
63.
that
Only
to
page
say that it was without jurisdiction.
Yes.
Page 63, two questions only. Evasive answers to two questions. That is the sole basis of his writ petition. As if the
Because
disciplinary
Mr.
authority did not
Mujumdar, you have to first prima facie make out your
But
case
paragraph 11,
of the.
writ petition, page 4.
No, that may be averment. We are not.
That has to be controverted
Paragraph 11,
at page 4. 4. Page 6, paragraph 18. And paragraph 21 at page 6.
paragraph 11 and
Paragraph 18 and 21. Eighteen,
18 and
18, 21, 23.
no, 18 and 21 are in the form of grounds, Mr.
This is also my.
Yes, yes. In the averments you have stated, 18 and 21 are the reasons why you say. But your sheet anchor is paragraph 11. Paragraph 11 again takes to that.
I come to know this fact.
Yes, yes, yes. That is your knowledge, and you are trying to rely upon that in support of your case that it's without jurisdiction.
Now, I'm not, for the time being, leave that
There are
apart.
two aspects, Mr. Mujumdar, I am telling you for this. One thing is to decide on that on the basis of the materials on record, or I can leave this issue open for you to agitate at the appropriate period of time.
May I put it in this way?
Because from this piecemeal documents, what you have, either this way or that way, that might affect.
For the time being, leave aside that examination or cross-examination of the witness. I have come before your lordship with a pleading of this nature. Your lordship's conscience is not persuaded prima facie to grant an order of stay. Final adjudication. High Court administration has to come up with its version as to whether it was taken at the full court or not.
Mr. Mujumdar, averments, what is this supporting materials on the basis of this?
Sir, I can't get a full court decision on my own. I say that there was no full court decision. It's for the High Court administration to disclose.
How have you said this, that there was no full court decision?
What is the basis of this?
What is
There must be some basis, my lord, of making an
that statement?
There must be some basis of a.
How have you affirmed that statement, that where is the specific statement that there was no full court reference?
18 is true to knowledge.
So, this is your positive statement on oath?
Yes, yes.
No, 18 is where it has been vested.
Right.
Tell me a specific statement which has no full court reference.
Paragraph 4.
Paragraph 4. No, paragraph 4 is where we are posted as a service case.
Right.
This is Jhargram.
Where is the positive statement stating that there was no disciplinary proceedings, there was no approval of the full court, or where is that?
But that's what I wanted to know from in course of the
You have to
proceeding.
you have to first assert that fact. Where is that?
Please come to paragraph 18, 21, 20, all these
Mr.
pleadings.
Mujumdar, 18 is subject to correction by you, is upon whom the powers are vested.
Yes.
I want to know, have you made any positive assertion in this application stating that it was not done by that? Where is that?
But please come to the second sentence of paragraph 11.
Paragraph 11?
Yes. But first sentence deals with the...
So this is the basis. If this is the basis, Mr. Mujumdar, then I will consider that.
But suppose that I don't have an indivisible right to...
Because for this, no separate opposition or anything is necessary, because your sheet anchor is, it has surfaced from this. This is your positive case.
Number
this
two
is to be only considered only on the basis of the evidence of PW1, whether it can be said.
That's one aspect. Number two, when an action is called into question before a court of law, regardless of what evidence has been elicited or transferred in an inquiry proceeding, it is for the...
So Mujumdar, how much time you will take?
No, I've almost concluded. It's for the... It's for the...
I have a bench at 2:30. That
Very well. No, it's for the court.
If I can post it after the vacation.
The records will be directed to be produced.
Millard,
because I have not heard Mr. Gupta.
Very well. But I have challenged an action on the ground of lack of authority. There may not be a prima facie case for success towards granting of an interim order.
No.
But I may ultimately succeed on the basis of the stand taken on the judicial side.
Mr. Mujumdar, there is no dispute on that proposition of law. So interim order is one thing.
Very well.
And final order is another thing. There is no dispute with regard to that. Only, you have to prima facie show something, your averment or any document.
Prima facie for what? For grant of an interim order. I am unable to show it to your lordship from the pleading so far that it is not a... This is a fit case for grant of an interim order. I am unable to show. This has to be tested.
That is one thing. Interim order is one thing. Finally, let us assume that the High Court administration is not present now. Let us assume that this case is proceeding ex parte.
Right.
You have to stand or fall on your own pleadings.
I know.
So then, accepting this, there is nothing. Let us, for the moment, issue the appearance of the administration.
Paragraph 4, 6, 8, 20, 21.
Even if it is decided finally at an ex parte, so you cannot improve upon what is there.
And I have stated in paragraph 4, 6, 8, 20, 21 and 18 that this has been taken not at the full court but by the administration.
But there is no statement with regard to that, Mr. Mujumdar. Where is, I am asking you, where is that positive statement?
Not to the extent that it is permissible from the records I have said, but I don't have access to records.
Mr. Mujumdar, when you are making a specific claim that the authority does not have jurisdiction, you have to take a responsibility to say that it was not done. Only then the cause of action arises, then and there it can be called upon by them. But you have not stated anything on affidavit.
Please.
Only you have said this has surfaced from this evidence. That is why. So I can proceed on that. That is one way. That is one way. Whether from that it can be said it's without jurisdiction, that is one thing. Because here there is no statement. It has only said that it has surfaced from there.
Now, today, the only case run by my client is lack of authority because the full court has not taken a decision.
You have not said
that. That's the sole case run. That's how the High Court administration understands this to be. But the sole thing required is I have got this decision. My case ends.
No, I could not follow.
The sole case run by the petitioner is the decision has not been taken in the full court.
You have not said that.
But I have said so.
Where?
Maybe as a ground, because it has not been done at the, maybe as a ground.
No, no, not at the ground, as the pleadings, anywhere. Show me one
But
sentence.
I say that the charge sheet is suffering from lack of jurisdiction because the appropriate authority, being the full court, has not taken a decision.
Show
I
me
have
that.
not stated it as a matter of fact.
Show me that
Please come to paragraph 18.
1-8. Please place 1-8. You have said upon whom it has been vested.
Yes.
You have not stated that it was not been issued by them. I want that specific assertion.
And all these
Mr.
allegations.
Mujumdar, when can I post it?
Please take it after vacation. Please take it after vacation.
Sir, convenience of both of you when?
Could be any date after the vacation.
Today, we know the provisions of RTI Act will not apply.
Second week after
Anytime.
after opening, second week in the week starting from 16th.
Yes.
Yeah, আমাদের 17th এ কিছু আছে? order record আপনি দেখুন ওটা। Mr.